For listing, my lord, some old cases, MSC appeal. They have to.
Pray before registry. All
My lord, we
cases,
went there.
all cases pray before registry. Yes,
My lord, I have come from Kolkata for item number 46, which is fixed for final hearing today. So if your lordship may hear it as first matter in the second, not in the first time. As for your lordship.
but you have to wait for your turn.
Yes, my lord, but that is the last item.
So what is your prayer?
If that can be heard, I mean, as per your lordship convenience today. Because I have come
If it reaches, I will hear it.
at 2, it is not possible to.
At 2, it may not be possible. Who is for the other side?
We did it, Becca, lordship is. His name has not shown in the corporate lordship.
It is also in the order and we have informed him.
Let us see.
Grateful.
MSC happened about 24. But it was listed on last minute on 18/9/24. Then long. So my friend, it may come on 24.
What was the order
It was a notice of issue.
and what was the order regarding listing next listing? In the order, notice was issued returnable within
4 weeks.
4 weeks.
But other steps was taken in the respondent.
In the second week of November, on a date to be fixed by registry.
May I please, your lordship? Your lordship, I beg to mention item number 14 and 15. I have taken consent from the appellant. Your lordship may kindly. 14 and 15. Lordship may kindly adjourn this matter for the day. As there is some compromise talk is going on.
You are for?
Respondent.
Who is for the appellant? You don't have any objection. Heard. What is your name?
B.U. Lashkar.
Heard, Mr. B.U. Loskar, learned counsel for the respondent / caveator. Also heard, Miss, what is your name? M. Haloi. M. Khatuniar, learned counsel for the appellant. It is submitted by learned counsel for the respondent that a talk of compromise is going on between the parties and there is a possibility of reaching an amicable settlement between them. On that ground, an adjournment is sought for today. Considering these submissions made by learned counsel, the prayer is allowed. Let this matter be listed after 4 weeks.
Any date after 6th of November?
No date, no fixed date, 4 weeks.
Published.
May it please the lordship. Lordship, I beg to mention item number 52 of the supplementary list, lordship. Kindly, this matter may be adjourned for 2 weeks. I have taken the consent from the other side, lordship.
Heard, Miss, what is
Saikia, lordship.
M. Saikia, learned counsel for the appellant? What is the ground for adjournment?
My senior is unwell today. He is having some health issues.
Who seeks an adjournment on the ground of, on medical ground. She also submits that she has informed the learned counsel for the respondent side, who does not have any objection to her prayer. Hence, the prayer is allowed.
Oh, please, lordship.
But the one pending MSC appeal, my lord. Here it was last listed 11/12/2020 for
Pray
announcement.
before registry.
Well,
Or
There
for
is
hearing.
no defects, my lord. It was a fixed for hearing, my lord, actually.
So it has to be listed in
Yes, my
hearing.
lord.
You have to pray before registry.
Oh,
If registry directs you to the court, only then mention.
my lord, otherwise, my lord, case was ready
You
for
go
hearing.
to the registry, it will list.
Oh, that's
Lordship, I am the petitioner of item number 37.
Yes. Yes. What is your name?
37.
M. Sharma, M. Lakar.
Yes, Manabendra law.
Yes.
Lordship, this matter has been fixed for order. Lordship, be pleased to give an opportunity to be heard before passing order, final order. I have not been heard.
No, it is listed today. It will be taken up when the matter is called. You have engaged counsel also.
Yeah, already counsel, but he was absent in the first date. So that's why I appeared as a in person.
Wait for your turn. When the matter is called up, we will take it up.
Alright.
May it please your lordship. Lordship, this MSc appeal pending, I beg to mention this MSc appeal, which has been pending since 2011. So,
Pray before registry at the first instance.
That please your lordship. Your lordship, I beg to mention for listing in RFA lordship. It's a money defeat lordship, realization money lordship. Any day after next week.
Fresh matter
RFA lordship,
in which column?
in hearing.
Pray before registry.
May I please your lordship, I would like to mention item number 9. Matter may be kindly adjourned for the day.
Which I am for the petitioner lordship. Lordship, in the, PCR has already reached lordship. Lordship, maybe, AP may be admitted and maybe fixed for hearing lordship. Any day as per convenience of the court.
Okay, we'll take up the matter when it is called up. Wait for your turn. We'll fix it for hearing, but wait for your turn. Let the matter be called.
May I please lordship, I beg to mention for listing lordship CRP, for withdrawal lordship, tomorrow lordship.
Okay.
Lordship, my lord, item 50 supplementary list. Yesterday I have mentioned this matter. It may kindly be upgraded and may be taken after motion matters.
No. 50?
50 supplementary. Today, case is fixed in lower court.
You have informed the other side regarding your mentioning. No.
Lord,
Have you informed the other side that you will be?
no, I will, if your lordship kindly permit, then I will inform.
No, first you inform, then mention. Then we'll take it up. If you inform the other side, we may take it up at 2 p.m.
May I please, your lordship? Lordship, beg to mention item number 33. Lordship, in this matter, lordship, P. Hazarika was there, he, on medical ground, lordship, suddenly, lordship, it happened, and we have taken the consent from other side, lordship. So,
What is your name?
this is Bora,
You are for?
petitioner, lordship.
Heard Mr. S.S. Bora, learned counsel for the petitioner who prays for an adjournment on the ground that conducting counsel, Mr. P. Hazarika, is indisposed. He also submits that he has obtained the consent of learned counsel for the respondent regarding his prayer for adjournment.
Lordship, interim is there.
Accordingly, the prayer is allowed.
Interim is there.
The interim order shall continue till next day.
We continue. Portion B, item number 1.
Make clear, lordship. This is a regular bail application, lordship. Earlier bail application was disposed by the honorable court, lordship. Prior to that, we have come here before the, in a POCSO case, lordship, section 6 of POCSO. Let the notice go, lordship.
Charge sheet has been filed.
Charge sheet has already been filed, lordship, and on the earlier occasion, the lordship directed us to go to the trial court. We have went there,
Trial court
filed-
rejected,
rejected the petition again, lordship. Our main contention was on the non-compliance of.
but notice
Six,
has to, notice has to go.
Notice to go, lordship, I agree, lordship, but,
We'll issue notice.
definitely, lordship, but I will insist for some interim bail, lordship. Just drawing attention of lordship on 27 page, lordship. Let the
No,
notice go,
the-
let the matter be heard on.
The
regular court.
nature of case is such that this court
I'm
is,
married, lordship, presently.
therefore
And
this
in
court is not
non-compliance of
not inclined to grant interim at this stage. We'll fix a short date
Lord.
on notice.
Thank you.
Otherwise, we'll appoint amicus.
I
Heard Mr. S. K. Poddar, learned counsel for the, yes,
Say something, lordship, regarding the lower court order, lordship,
regarding
lower court bail petition, rejection of the bail petition. It has
In
been
this
stated-
case?
yes, lord. It has been stated that the accused is my relative.
accused,
Accused is my relative, my own brother-in-law. And lordship, it is stated that 47 has been complied with the court order, lordship.
complied through me, Lordship. So I would like to file my affidavit also. That may kindly be done.
You file a wakalatnama.
No, Lordship, I am the 48 has been complied through me. So I'll put.
No, what is your locus?
May I clear one point, Lordship? Advocate Agarwala is the brother-in-law of the accused. In the order sheet, somehow on the basis of police mentioned his name.
Yes,
That 48 compliance, we have challenged that part, 48 has not been complied with.
he's saying that 40 has been,
Learned Trial Court has brought on record that the notice was served on Mr. Jamil or Jamil on the instruction of Mr. A.R. Agarwala. That's why he is
So I would
also
like to
trying
file
to
affidavit
file
on
an
this.
affidavit on that.
What is the?
you can file affidavit.
Yes.
There's no need for him to file it.
You can file affidavit. Why to allow? If
Otherwise, I
you,
am not interested.
because it is your case, how he is interested?
So Lordship, my.
We have taken that ground, Lordship.
We will examine the matter. We are not allowing you to file affidavit now. We'll examine the matter.
We have taken the ground of non-compliance of
My name
47
will
and 48. Lordship.
become-
Name of many witnesses are there.
No, no.
We cannot allow each and everyone.
Regarding the rejection.
Let us examine the matter. Let the record come.
Lordship.
Heard Miss S.K. Poddar, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner for the second time seeking bail. No, not seeking bail, second time by the petitioner who has been detained behind the bars since 9/8/2025 in connection with Sessions Special Case Number 192/2025 corresponding to Paltan Bazar PS Case Number 229/2025 under Section 65 within bracket 1/87 of BNS, read with Section 6 of the POXO Act 2012. Let the notices be issued to the respondent number
Informant is the police officer.
3,
And 3, we have mentioned the victim. but
respondent number 3.
I have not disclosed the name, Lordship. So we may be allowed to serve through the OC Patan.
Respondent number 3, in pursuant to the prevailing notification of the registry in this regard, the petitioner shall take steps for issuance of notice on respondent number 3 within 3 days from the date of this order, returnable on when?
Lordship, it may be fixed on 24th if permissible. Lordship. 23rd or 4th.
Why the notices cannot be issued to the victim herself, Lordship?
We are issuing to victim.
But
3 is the victim.
here also the address of the victim is not given, Lordship.
No, otherwise it comes in order sheet, Lordship. That's why the disclosure, name will be
No,
disclosed. Lordship. That's the
they
problem.
will, in the notice, they will mention the address and name.
In notice, I can mention, Lordship, and send it through.
Yes, to the registered address of the victim, Lordship. It has
Yes.
to be here.
Names
Through,
are-
through OC of the concerned police station. They have to furnish the names.
Name is with me, Lordship, in the chart sheet.
Okay, while
why-
taking steps, you mention
Yeah,
the
Lord.
name.
And I have, that's why mentioned in the my petition also, Lordship. Notice to be served through OC Paltan Bazar PS. If
Well,
it's possible, Lordship, within 24,
28,
28.
28, Monday. Let this matter be listed on returnable on 28th of October. Stop. Mr. A.R. Agarwal, learned counsel, has submitted that he has been instructed by whom?
Himself.
I, your Lordship. So I have given my name. So 50
No,
has
no.
given-
Who is your client?
Nobody is my client. I'm just independent witness. Because
What
my
is your name?
K.R. Agarwala.
His
Ye-
name figured in the order sheet. Lordship.
In
That's-
person?
Yes, in person, Lordship.
My name has
That-
been shown in the voter sheet. That may kindly perish.
Okay. Mr. A.R. Agarwal appearing in person has submitted that
My name is.
the trial court, while deciding the contention of the petitioner, when the bail was moved before the said court, had observed that notice under section 48 of BNSS was served on one
One,
Jamir.
31, just,
What is the name?
just. Jamir Hussain.
One Jamir Hussain on the instructions of Mr. A.R. Agarwal. And therefore, he seeks leave of this court to file an an affidavit in this regard. Considering the submissions, this court is not inclined to allow the prayer at this stage without perusing the record. List the matter accordingly.
Date.
28.
Oblige.
Maybe. It's a regular bail, my lord. The lordship will find the FIR at page 11, my lord.
First bail,
My lord.
first,
First.
why it
Earlier-
has come to this
Earlier,
court?
the anticipatory bail was rejected by a lord. That I have been told my friend,
It is pending investigation.
pending investigation.
We'll call for the case.
My
hearing.
lord, only one prayer matter, a small prayer matter, if your lordship turns to page 22. Otherwise, I am behind the bar for 45 days and it is a 60 days mandatory period for filing charge sheet, my lord.
What is the offense?
Offense, my lord, cheating, my lord.
We'll fix a short date
No, my
for
lord, only one submission, my lord. If your lordship turns to page 22 for a once, my lord.
20.
22, my lord.
Yes.
Fourth line, my lord. My lord, it's a medical report, my lord. Cited, my lord, so and so tension-free mesh hernioplasty essay on 19/10/25. My lord, he is suffering from hernia, my lord. And his, my lord, operation is scheduled on 19/10/25, my lord. Essay, my lord, this is, my lord, spinal anesthesia, my lord. My lord, this person had number of cases, my lord, 4 or 5 cases, my lord. Yesterday also, we moved some cases in this court, my lord. But I'm praying for interim, my lord. This order was passed by a coordinate bench of this court, my lord. The lordship, my lord, please.
But without perusing the report of the medical officer, in jail you will be
Yes,
treated.
well, my lord, this is the GMC hospital, my lord, GMC hospital.
When you are asked to surrender,
My lord, on or before 7th, my lord.
yes, Mr. Sharma. A coordinate bench has granted interim bail to him.
One more case tomorrow it's coming, my lord, same, my lord. I will surrender on or before 7th, my lord. That was the order passed.
Okay. Heard Mr. N.J. Datta, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 483 of BNSS 2023 has been filed by the petitioner, namely Dharmeshwar Roy, who has been detained behind the bars since 3/10/2025 in connection with Nunmati PS case number 22/2025 under section 316 within bracket 2/318 within bracket 4/11 111 within bracket 2 of BNS. Stop. Learned counsel for the petitioner has submitted that the petitioner has been detained behind the bars in connection with the aforesaid case for last 45 days. And he is suffering from, you are suffering from what?
My lord, ingenial hernia, my lord, last page 26, my lord.
Suffering from ingenial hernia and has been prescribed surgery on 19/10/2025. He further submits that there are other cases pending against the petitioner, and in one of the case, that is GR case number 2869/2025, a coordinate bench of this court has granted interim bail to the petitioner so that he may undergo the surgical operation. The said order was passed by the coordinate bench in bail application number 3109/2025 on 14/10/2025. The learned counsel for the petitioner has submitted that unless the petitioner is granted interim bail in the instant case, is the interim order of bail granted in bail application number 3109/2025 would become infructuous, and he may not be able to undergo surgery as prescribed to him by the doctors. What is your submission? Stop. Learned counsel, learned additional public prosecutor, prays for calling of the case diary. Let the case diary be called for. Let this case be listed on 12/11/2025. In the meanwhile, considering the medical urgency of the petitioner, if he is arrested before the next date fixed in connection with this case.
It is BL also.
Oh, sorry.
BMI already.
A line to cut it out. Considering the medical urgency of the petitioner, he is allowed to go on interim bail of rupees 50,000 with one surety of like amount, subject to the satisfaction of learned Chief Judicial Magistrate, Kamrup Metro, with following condition: that the petitioner surrender before the learned Chief Judicial Magistrate, Kamrup Metro on 7/11/2025 positively. The petitioner shall also file an affidavit before this court intimating this court regarding compliance of the condition imposed above. List this matter again on 12/11/2025 for case diary.
So that order may be kept as a part of the record.
Let the order dated 14/10/2025 in bail application number 3109/2025 produced by learned counsel for the petitioner be kept in the record of this case as a part of it.
I'm obliged, deeply obliged.
I think 48 from supplementary list.
The hearing matter we may take up at 2 because they were not notified that we will be changing the
So can it be at 3?
3 p.m. 2 bail hearings are there, na?
I have a partner method, Lordship, at 4:21.
Okay, at 3 p.m. we will take up bail hearing matters. Now we'll take up civil matters.
Lordship, item number 12. It is also listed for hearing, Lordship. Here, the petitioner is already on interim. CD has not been received, so date can be given. for-
Okay, we'll take up criminal matters at 3 p.m.
Item 3.
Yes.
Lordship, we are petitioners in person.
Yes, what is your case?
The remand order from Honorable Supreme Court. The remand order, it was specifically mentioned.
Where is the remand order? Page number? What do you do?
My lord,
What do you do?
I had a business, but I had surrendered my business.
Why have you not engaged a lawyer?
I have financial constraints, my lord.
You can take, if you have financial constraint, because I have gone through your petition. What is your grievance?
Orders have been passed, interim orders have been passed. After the remand order. The very fact that CRPF is a necessary party. DGP has not been included in the reference case.
No, the Supreme Court, the apex court directed to implead CRPF.
Yes.
So the trial court has impleaded CRPF.
Only the
CRPF will be represented by some, who is representing CRPF?
Commandant 34 Battalion. But in the SLP, DGP was a necessary
No,
party.
what is your, which order you are impugning?
Order dated 3rd April 2025, 30th May 2025.
3rd April, which is the page?
It is
Have to come to page 44
Page 44.
of the revision petition.
47. 47 is the page number.
Forty-seven is 35. It is page 44.
Yes. This is an order where only Commandant 34 Battalion and Union of India have been implemented. DGP, CRPF have been excluded. DGP, CRPF read before Honorable Supreme Court that we were a necessary party and we were not heard during the first hearing, during the earlier disposal. Now, without a necessary party, decree that will be passed will be ineffective.
Where is the order of the apex court? Where it directed that DGP is the necessary party.
Page number 36 to 40.
Where is that observation? That DGP is a necessary party.
It is said on the Union of India and CRPF. CRPF is the beneficiary of land acquisition.
Your land was acquired.
My lord,
Your land was acquired. How much compensation Deputy Commissioner granted to you?
9.7 crores, my lord.
And how much it was enhanced?
338 crores.
Later on, that order has been set aside by the apex court,
Yes, my lord.
and a fresh the reference has been remanded back and for fresh consideration, and the trial and the law authorities has, no, you have to show where it has erred in not complying with the apex court's order.
DGP, CRPF, without the DGP, CRPF, my lord,
Yes, Mr. Goswami.
CRPF being an authority under the Ministry of Home Affairs, the Union of India is a party. The land acquisition proceeding was for the 34th CRPF battalion. That has been made a party. BJP may not be a necessary party here.
Yes,
And
CRPF is represented. They will be making payment. So how it affects your case if DGP is not made party?
DGP being
It
the
is not
head
the
of the
CRPF.
organization.
the payment has to be released from the Ministry of Home Affairs. Because it is an
Yes.
authority of the Ministry of Home Affairs.
What else is your grievance?
The order have been passed. This order dated the 3rd April. Without the appearance of the party, directions and order was issued.
Appearance of whom?
Appearance of the respondents. Respondents were not even put on notice.
But they are not aggrieved.
Lordship will come to page 46. Lordship will come to page 46. The case was taken up on remand after the petition was filed by the petitioner. By the order dated 3/4/2025, notices were issued to us. Pursuant to that notice, we have.
You are representing CRPF also. Okay. CRPF is being represented. Then,
Also.
yes, then there is no illegality, apparent illegality, which justify invoking of powers under 227. That is my observation. What else is your grievance? At what stage the reference is pending now? You have submitted your affidavit.
We were not allowed to file affidavit.
Have you submitted now or not?
No,
If
we have not.
If I may, Lordship.
Yes.
It is not that he has not been allowed. He has not filed. In fact, on the last occasion also, it was, I think, on 20, just a few days back, 25/9. The Honorable Court asked him to file his affidavit. The case is pending at the stage of issues. He has not filed his draft issues. He's taking time. He says, I have not filed. Court said, you file it today.
No, suppose drafts issues are not filed. Court can,
Yeah.
Court
I have
can-
filed. Once he says, I will file, then he says, I will not
I
file.
haven't said I will file. I was never given, and the sequence of filing affidavit and objection is very clear in the remand order. First, the respondents, we are respondent number 2 and 3.
you file affidavit before the district judge.
We were
Yes,
not
he will
allowed to
file.
file,
I
madam.
have no objection to that. Fine.
There is no mention of framing new issues. One issue has already been framed by Honorable Supreme Court in the remand order with respect to 4 letters that were obtained from us under duress and coercion. That is the only matter which is supposed to be decided.
Where the Supreme Court has framed the issue. Let him.
At page, in the
No, what
the
was,
remand order,
what is the content of those 4 orders?
in the remand order serial number 10,
No,
my lord.
answer my queries. What are the contents of those 4 orders? You accepted the,
We had to offer our willingness because our land was mortgaged. It was mortgaged in 2009, 2010. We
so
could
the
not-
apex court said that whether those 4 letters are obtained under duress,
Yes,
that
yes,
has to
my
be
lord.
decided.
yes, my
That
lord,
will be decided by
That will be decided by the court.
the court.
but it was none of the 5 orders issued by learned reference court. This issue has been reflected in no single, not even a single order has reflected this issue. This is the only issue that has been framed by Honorable Supreme Court.
No, it can still frame the issue. This is not the only issue. The matter has been remanded back for decision afresh. So everything has to be decided in addition to this issue. that whether some letters were obtained from you under duress or not. Where is the
My
order
lord, I have filed a interlocutory application also.
that you have filed before the wrong court? Under order,
Order 12, Rule 6.
why have you filed that before this court? This court will not decide your reference. It has to be filed, if at all it is maintainable, it has to be filed before the reference court. Therefore, I posed a question to you at the very beginning. Why haven't you engaged in counsel? Otherwise, you will spoil your case. If you interfere now, it will linger your case. You have also prayed for stay. You are the petitioner before the reference court. Yes, Mr. Dev Chaudhary, what is to be done?
Lordship, the grievance raised by my friend, that does not call for any consideration, my submission. And in fact, it is in his interest that the reference case should proceed.
Yes. Now, where the court has not followed the directions under 12,
None of the orders contain any mention about these 4 letters.
No,
This is the
that's-
issue.
that stage has not arrived. While after getting affidavit and objection by the both sides, court may frame issues. We'll direct the what else is your grievance? That issue regarding
The
those,
recorded evidence which I exhibited and proved before the earlier disposal are now missing. And are missing from the case record. As many as 432 pages of documents are missing. And it has been recorded in the order dated 29 August 25.
if that is missing, there are ways to find it out. If it could not be found, then there are provision for reconstructions of missing record.
In that context, Lordship may see page 64.
Page,
Page 60 for a moment. That is a part of the order dated 29/8/25. The last paragraph,
which para?
the last paragraph, Lordship.
Para 9.
No, it's order dated 29/8/25. It starts with seen the report. Of
Page
the
64 is a different order.
60. 60,
Yes. In the report.
yes.
Yes.
It
Please
is only
read.
after reporting that the records are missing.
Please read.
Seen the report filed by the bench assistant, wherein he has stated that as per direction given by the order dated 7/8/2025, he has inspected the case record of reference LA 1 of 18 in search of the file of 230.
This record is missing.
Yes, now he has given a report. It is seen that the case records of LA case number so and so were sent back to the office of the deputy commissioner.
Okay. Then it
Now,
has to be recalled.
As per the dated 25/22. So as per the
Find
order,
out LA case
No,
number.
let him, I will come to you. Yes.
25/22. However, as he was not the bench assistant at that time, he needs further time to consult with the then bench assistant and also with the dealing assistants to tracing out the documents. Considering the nature of prayer made, the time is allowed.
So an endeavor is going on to search.
And next paragraph also call for the entire case record of LA case number so and so from the district collector. It was sent back.
This is the last order
After that, it has come once, Lordship,
on 29/5.
on
On 25/9,
25.
the
Yes.
trial court granted you opportunity of filing affidavit. Have you filed it?
In the meantime, I sought this remedy of filing revision petition, my lord.
Against which order?
Only 5 orders. 5 orders of the.
But when the trial court is granting you the relief, why to rush to this court?
So as to obtain a speedy order, speedy judgment under order 12 Rule 6, my lord.
No, we are
Because
we are
claims are
not
admitted,
we are not inclined to.
claims are admitted and admission of facts are made. It is crystal clear that CRPF does not have any role in the acquisition proceeding. And payment.
Who will
of-
be paying money?
payment of
Requisitioning
compensation.
authority
For the CR.
or the CRPF?
And in fact, in the reference case, why we had to go to the Supreme Court was in the.
Ha-
reference
Have you
case,
obtained, have you received any amount till now?
So
Nine.
That was given by collector.
And
Before
you
the
say
reference-
that you don't have money to engage counsel.
Yes, my lord.
You have received 9 crores.
I have received 9.7 crores, my lord, but I had problems.
We are dismissing this. Civil revision petition. With an observation. We'll give certain observation that you may file your affidavit. Even if you have, if you have failed to file it on 25/9, still you can file it. Yeah. Heard Mr. Hareshwar Bora and Miss Madhumati Bora, petitioners who appeared before this court in person. Also heard Mr. R.K. Dev Chaudhary,
I have for 2, 3 and 4 lordship.
learned Assistant Solicitor General of India.
Deputy
Sorry, learned Deputy Solicitor General of India, appearing on behalf of respondent number
lordship. Yes.
2, 3 and 4. Also had Miss D.D. Burman, learned Additional Senior Government Advocate, appearing for respondent number 1. This application under Article 227 of the Constitution of India has been filed by the petitioners impugning the orders dated 3/4/2025, 35/2025, 3/7/2025, 7/8/2025, and 29/8/2025, passed by the Land Acquisition Settlement and what is the full form of LAR?
Land Acquisition and Resettlement Authority.
No,
Land Acquisition, Rehabilitation and
Rehabilitation and
Resettlement Authority.
Resettlement Authority, Nagaon. In LA appeal number. Oh, in which case it has been? In LA case number,
Reference LA case number 1.
in reference LA case number,
15.
where is the mention?
Lordship, page 44, lordship, top.
1 of 18. I'll pass the orders in chambers. I am dismissing your petition with an observation that you may file your affidavit as directed by the apex court on the next date fixed, and with a direction to frame whenever issues are framed, issue should also contain an issue as directed by the apex court regarding whether the letters referred to in the order were obtained under duress and coercion. That issue, that directions I am giving.
My
You,
lord, the other side have already filed a draft issue.
no,
This-
I'll address everything in my order. You see the order tomorrow in the website. Your case is dismissed.
Item 47 from supplementary list.
Obliged, my lord.
Yes.
Actually, I am appearing for the caveat, my lord. My senior is in bereavement.
Our issue is, my lord, that our AGM,
Bereavement, so what is your prayer?
So matter may be taken up any other time.
After how many days?
After a week, my lord.
Because after 30 days, the matter would otherwise be heard.
yes,
By the-
my issue is, my lord, only that our AGM was stalled by that order, appellate court, and there was no prayer. There was no prayer of either permanent or temporary. And therefore the learned lower court has rejected the injunction application. We have 697 members, this society. This is the only hospital, my lord, where
No. The respondent here, he filed a suit,
the respondent has filed a suit.
filed a suit.
Only grievance is, para 4 of the plaint, my lord, may kindly see. Only issue is that we have not placed the annual general, this audited
Audit
report
report.
of 2024 and 25. That was his grievance. And that is, we have already completed. So we are only permitted to hold the annual general meeting in accordance with our rules and regulations. And that their grievances that was raised in the suit, that the audited report of the last financial years, that was not placed. And we have already completed.
You have come,
Yes, we have to place. We have to hold the meeting by giving a 21 days notice, and we'll place this. This is the only issue.
yes.
So therefore, my lord,
You
so
have
we have
to,
already completed 3 years.
that 25/9 has lapsed.
Yes, 15.
No,
Regulation 15 says that I have to place the last proceedings, preceding year's audited report. Rule 15 says. While we placed the notice for holding the general meeting, that report was not annexed. There is some difficulties in the auditor was not submitted the report in time. Now, meanwhile, we have completed to hold the meeting. What's the grievance?
You will have to issue fresh notice. After issuing fresh notice,
We will.
yes, then you will not be aggrieved anymore.
No, my lord. I am not aware of the matter, my lord. My senior is aware of it.
No,
So
no,
I am praying
record shows, my
that
lord.
any date-
Record shows, Lordship, kindly have a look at page 21, the plaint, paragraph 4.
Yes, now if we interfere, it would only linger the matter again. Your grievance before the trial court was to hold meeting in compliance with the rules, after following the rules. Now they are ready to follow the rules. And where is the error in the appellate court's order?
The appellate court, my lord, in the plaint, they have not prayed for any permanent injunction as well as the temporary injunction. They have prayed for a mandatory injunction. And they have challenged the AGM that was scheduled to be held on 21st of September. Now on 19th, the injunction petition was dismissed by the trial court,
19th of September.
19th of September. They have preferred the appeal on the same day.
without copy. Then the matter was fixed on 24th of September. So therefore, the entire suit is infructuous.
Yes.
The declaration was sought for that the 21st September meeting to be declared to be a null and void for non-compliance of this. The suit goes. But remains, my lord, now at this stage. And on 24th, the Learned Appellate Court passed an order of status quo. And that too, my lord, that it is a settled position. You have to pray for a permanent injunction and also the temporary injunction without any prayer. And we are now only wants to the leave of this Honorable Court, my lord, that to hold the meeting in pursuance of our rules and regulations. We have 697 members, and these
Okay.
respondent is alone.
You have furnished the copy of petition to the KV. You are the KViter. You have filed.
Already.
You go through the petition. We'll dispose of this matter at 2. We'll
Right.
take it up at 2. Try to dispose of the matter at 2. Even if your senior does not come, you take instructions and you plead the matter. We'll take a tap. Let him,
No, for complicated
but,
facts and law is involved here.
but he's entitled to get an opportunity.
Absolutely.
Let him go through.
And therefore, caveat, my lord.
Yes,
Caveat does not mean that you have to adjourn the proceeding.
yes. No, we'll take it up at 2.
Problem. For
Make visual option. My lord, the probate granted by the London district judge is under challenge in this petition. The grounds of challenge primarily, my lord, are that, my lord, the probate application was not in proper format.
It would require a lengthy hearing.
It
Hearing would be
will-
long.
It will take.
We'll admit the matter and fix it for
My lord,
hearing.
admission will make, my lord, the hearing to come up very late, my lord. Let it be at the, my lord, admission stage itself.
We'll fix a date of hearing if you agree. Because
What happened, my lord?
taking up a probate matter in
Yes.
admission hearing, it may, other lawyers will not get to take it.
I appreciate that, my lord.
Huh?
Hearing, your worship will kindly give a date for.
We'll give a fixed date for hearing.
My lord, the anxiety is that, my lord, the case was not properly conducted, my lord, and in the meantime, although there was initially there is a stay order, the probate certificate has been granted, and perhaps, my lord, according to my learned friend, my lord, that has been acted upon by mutation also. That's why there is urgency. A date may be fixed as per conventional option.
Immediate, my lord. I will go.
This is, I think.
Heard Mr. M.K. Chaudhary, Learned Senior Counsel, assisted by Mr. M. Sharma. Also heard Mr. G. N. Sahewala, Learned Senior Counsel, assisted by Miss S. Agarwal, appearing for sole respondent.
Yes.
Appearing for the sole respondent.
Oh.
Appearing for the respondent.
Oh, that's another one. That's another one.
What has happened
I
to,
mean,
as regards other respondents?
nobody appears, my lord.
None appeared, my lord, they are served.
Stop. None has appeared for the other respondents. This case is ready for hearing, hence it is admitted for hearing. Stop. Let this case be listed for hearing on.
My lord, may I suggest 4th of November, my, it's a Tuesday.
Yes.
Okay. Let this case be listed for hearing as a fixed item on 4th of November.
Highly obliged. This appeal is filed
against the original judgment and decree, Your Lordship.
What is your name? Heard Mr.
Era.
A. Rahman, learned counsel for the appellant. This appeal under Order 41, Rule 1, read with Section 97 of this Code of Civil Procedure, 1901, has been filed by the appellant, Srimati Saraswati Chakravarti, impugning the judgment and decree dated 30/7/2022, passed in suit was decreed or dismissed?
Dismissed.
Passed in title suit number 11/2015. There is a delay. Delay has been condoned.
My lord, this appeal is filed long back, my lord. No delay. There is no delay in filing, my lord.
But it is, why it is listed so late?
It's listed in defective, my lord. And, so there is some late in listing.
Okay. क्या लिखा? Then, like 15, by the Court of Learned Civil Judge Dhubri, whereby the suit was dismissed by the trial court. Issue notice to the respondents and call for the records of the trial court. Registry to take steps for requisitioning the records of the trial court. The appellant shall take steps for issuance of notice upon the respondents by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. List according.
It is admitted.
Yes, it is, the appeal is admitted.
Plus,
My lord, items 6 and 7, both matters are out of same suit and two miscases for injunction application. One is under dated 1st of February 2024, that is item number 6. Here, this honorable court has passed an order for issuing notice, but the appeal was not been admitted.
Have you taken steps?
Yes, I have taken steps. I've taken steps on the very next day. 15/10. Sorry, 16/9.
What was the order?
Order is. dated
Ex parte
15/9.
interim injunction was granted.
Yes, ex parte interim order was granted stating status quo with regard to the inquiry proceeding initiated against the respondent. This is a non-government, it's in the
What is the next date before the trial court?
27th of October.
Now what is to be done?
My
You
lord,
could
this-
have appeared before the trial court and prayed
No,
for
this is
vacay.
the second round of earlier against this order. I filed an CRP IO before this honorable court, and your lordship will find that judgment by which this was rejected only on the technical issue that there is a provision for appeal that your lordship will find page 170.
The
Earlier
miss case has been disposed of.
No,
You have been afforded opportunity to file objection.
I have challenged when the notice was issued, I have challenged on the ground that this district judge come educational tribunal doesn't have the jurisdiction to entertain such the suit as well as this miscellaneous application. Because it is a minority educational institution and this educational tribunal has no business over the minority educational institution. Lordship will kindly see the certificate first, which is page 104.
Oh, okay, no, notices have been issued.
Is
We have
this
to-
is not-
We have to wait.
But inadvertently, the appeal was not admitted.
We'll admit the appeal.
Man,
Heard Mr. A. Dhar, learned counsel for the appellants, who is appearing for the respondent number 2.
respondent number 2 is education. Their name has been shown.
None has appeared for respondent number 2, though on last occasion, that is on 15/9/2025, learned standing council education, secondary education department had appeared. It appears from the office note that notices were issued in respect of were issued to respondent number 1 in pursuant to directions of this court, however, the service report is still awaited. We'll await further. This appeal is admitted. List accordingly after.
After it, my lord, along with the item number 7, this is very important.
After 3 weeks. After 3 weeks on the date to be fixed by the list. No. In IN, notices have been issued.
Yes, we have taken steps.
In
Although there is
IN,
no order.
IN means main case, same order, common order. ইয়াত এটা কপি লগাই দিব common order.
Yes, there was a common order. In item number 7, lordship, that was passed prior to the item number 6. That is miss case number 4 of 2024 in title suit number 1 of 2024, whereby the learned district judge come educational tribunal has directed to pay the school half of the salary of the petitioner in a wrong interpretation of jurisdiction. Lordship may come to the order at page 60. That is 8/1/2024.
Yes.
Lordship, page 61. Earlier, the respondent number 1 has preferred to read petition. Those were dismissed. I'm just reading page 61. However, we are clarifying that we have not expressed on any view on the legality of the acceptability of the communication dated 4/4/2022, by which the service of the petitioner has been discontinued, nor in respect of any reasons stated therein. In para 20 of the order, Honorable Guwahati High Court stated that the petition is held to be not maintainable on technical aspect of maintainability of application under 226 of the Constitution of India in respect of an ordinary contract of service between the respondent Montfort School High School and the petitioner. As the writ petition has been dismissed on technical aspect as indicated above, liberty remains with the petitioner to approach any appropriate forum if so advised, and the dismissal of this writ petition shall not be constituted to be a dismissal on merit of the claim of the petitioner against the communication dated 4/4/2022. So the petitioner filed a suit, title suit number 1 of 2024 before the learned district judge come educational tribunal, assailing this order communication dated 4/4/2022. Your lordship will see the prayer as page 38. Prayer made in the title suit. Now, the learned district judge has held at page 61, heard the learned, last paragraph I'm reading, heard the learned counsel for the petitioner and perused the documents carefully. I find that the Honorable Guwahati High Court dismissed the writ petitions on technical ground and gave liberty to petitioner to approach any other appropriate forum. Accordingly, the petitioner has filed this petition as by notification number so-and-so dated 13/12/2015. The government of Assam, as per recommendation of Honorable Guwahati High Court, designated the Court of District Judges and additional district judges of each district to function as educational tribunal to adjudicate disputes relating to teaching and non-teaching staff of the non-educational institutions, as well as disputes concerning disciplinary action and claim of the provincialization in respect of teaching and non-teaching staff of the venture educational institutions within the respective territorial jurisdiction. In the present case in hand, the respondent opposite party, that is the Montfort School, is a non-government educational institute. Hence, I find this court has jurisdiction to entertain this case and this case. Accordingly, the ex parte ad interim in prayer for the petitioner is allowed. The office are directed to pay the half of the salary each month to the petitioner for filing till filing of the written objection by the office in the missed case as per their terms and conditions. The office are also directed to pay the half salary till date of the till date to the petitioner. Now, assailing this order, earlier we have filed an CRP IO, which your lordship, which was first initially stayed by order dated 23 of February 2024. Your lordship will find at page 145. Then proceeding of that this case was stayed. Thereafter, but the private respondent has not appeared in that case also. Thereafter, at page 147, by the judgment dated 16/6/2025, this coordinate bench of this honorable court has rejected the application with an observation that although this is a non-government organization, this is a non-government minority or educational institution, there is a scope for filing an appeal. Page 154, your lordship. Paragraph 15. A liberty was granted to the petitioners. 154. Taking
Yes.
into account the both the petitions have been dismissed on the ground of non-maintainability, liberty is given to the petitioners to assail the impugned orders dated 8/1/2024.
Which petitions were rejected?
Those two, this item number 6 order, as well as here in it is 8/1/2024. Passed in Ms. J case number 4 of 2024. As well as order dated, both the petitions were taken together. If so advised, and the period from so and so date to be excluded while computing the period of limitations. So we prefer this
No, you are impugning which order?
8/1/2024.
8/1.
8/1/2024.
You preferred in CRPIO earlier also.
Earlier, that was dismissed for non-maintainability because 227 court cannot go into the date. Court said you can prefer an appeal against that order. Accordingly, we have preferred this FAO. Before this court. Assailing this order on the only on the ground that this minority educational institute does not come within the definition within the purview of the 2006 Act. That has been also discussed in the judgment also.
Where?
My lord, one page. My lord, page 153. Paragraph 10. The court further finds it relevant to take note of the definition of non-government educational institution as contained in section 215 of the Act of 2006. Section 215 of the Act of 2006 being relevant is reproduced herein below, herein under. Non-government educational institution means schools established and run by an individual or association of individuals or any non-government organization or society or trust, except, kindly note this word, except the schools established and maintained by the minorities under clause 1 of Article 30 of the Constitution of India and imparting education as primary, middle, secondary, higher secondary level without receiving any grants in aid from the state government, excluding the education institution run or aided by the central government or the state government. So these minority educational institutions are exempted from the from the purview of this non-government educational institution. And we are a non-government minority education. With this respect, a certificate was also issued, page 81. This is our only case. This educational tribunal doesn't have the jurisdiction to try any dispute.
Page 81.
Page 81 is a certificate issued by the National Commission for Minority Educational Institution.
What it certifies?
It certifies that
You are declared as minority.
minority educational institution. And 2006 speaks only about
What is the 2006 Act? Full.
2006 Act is under Assam Non-Government Educational Institutions Regulation and Management Act, 2006. In fact, when the respondent number 1 assailed that those orders in the writ petition, 2 writ petitions, this honorable court also held this is not maintainable, writ petitions are not maintainable because it is a minority educational institution.
Writ petitions are not maintainable
Not maintainable.
and neither it can be raised before.
Suit can be filed, but not before the educational institution.
Okay, normal suit.
Normal suit.
Okay. Heard. Mr. A. Dhar, learned counsel for the appellant. This appeal under order 43 rule 1 R within bracket R read with section 104 of the Code of Civil Procedure has been filed by the petitioners,
Yes.
by the petitioner sorry, by the appellants. Who are you? You are the school. By the appellants impugning the ex parte interim order dated 8/4/2024 passed by learned District Judge cum Educational Tribunal, Dibrugarh in Miss J case number 4/2024 arising out of title suit number 1/2024, whereby the appellants were directed to pay half salary each month to the respondent till the filing of the written objection by the opposite parties in the said Miss case. Learned counsel for the petitioners has submitted that the petitioners are petitioner number 1. Learned counsel for the appellants has submitted that the appellant number 1 is a minority educational institution covered under section 2 within bracket G of the National Commission for Minority Educational Institution Act 2004, and therefore it is outside the purview of the operation of Assam non-government government educational institution within bracket the Regulation and Management bracket close Act 2006. Learned counsel for the petitioner, learned counsel for the appellant submits that section 2 within bracket Roman 15 of the aforesaid act exempt the schools established and maintained by minorities under clause within bracket 1 of the article 30 of Article 30 of the Constitution of India, and hence he submits that the impugn order passed by the Educational Tribunal Dibrugarh is beyond jurisdiction. Issue notice to the respondents.
Respondent number 1 has been served copy. It's education. Sorry, respondent number 2. Their name has not been shown in the copies.
Somebody is represented these.
Copies, Educational Standing Council of Education Department is
Stop.
there.
Learned counsel for the petition appellant submits that since a standing counsel is there in this court representing respondent number 2, that is the Director of Secondary Education, the appellant has already served notice as well as copies of the memo of appeal along with annexures to the said respondent. Therefore, no formal notice need to be issued to the said respondent. However, as regards the respondent number 1 is concerned, the appellant shall take steps for issuance of notice upon respondent number 1 by registered post with ID as well as by usual mode within 7 days from the date of this order, returnable on 14th of November 2025.
But in the meantime, what happened, the respondent number 1 has filed an application before the Learned Educational Tribunal. Although she has not participated in the CRP proceeding, she has filed an application for releasing that amount. So this, I'm praying for stay of the this impugned order. This IA civil.
Separate IA has been filed. Third, Mr. A. Dhar, learned counsel for the applicant. This application under Order 41, Rule 5 of the Code of Civil Procedure 1908 has been filed by the applicants in connection with the first appeal against order number, in connection with the FAO number 66/2025 filed by the petitioners, impugning the order dated 8/1/2024 passed by learned District Judge cum Educational Tribunal, Dibrugarh, in Miss J case number 4/2024, arising out of title suit number 1/2024, whereby the present applicants were directed to pay half salary each month to the respondent till filing of the objection by the present petitioners in that missed case. Learned counsel for the petitioner learned counsel for the applicant has submitted that the aforesaid order dated 8/1/2024 passed in Miss J case number 4/2024 by the Educational Tribunal Dibrugarh has also been impugned by the present applicants by filing the connected FAO number 66/2025. He submits that said FAO has already been admitted and notices were issued to the respondent. He further submits that the main plea taken by the present petitioner in the connected appeal is regarding lack of jurisdiction of the Educational Tribunal to try the said title suit, as the applicant number 1 is a minority institution, minority educational institution, which is exempted from the purview of the Educational Tribunal under section 2 within bracket Roman 15 of the which act? Assam?
Assam non-government educational
Of the Assam Non-Government Educational
institution, Regulation and Management Act 2006.
Non-Government Educational Institution within bracket Regulation and Management Act 2006. Let the notices be issued to the respondents. The applicant shall take steps for issuance of notice to respondent number 1 by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable on what was the date? 14th of November. Since the respondent number 2 is represented in this court by a standing counsel and notices have already been served on him, no formal notice need to be issued to respondent number 2. Stop. In considering the submission made by the petitioner, made by learned counsel for the petitioner regarding lack of jurisdiction of the Educational Tribunal in passing the impugn judgment, impugn order, the operation of the impugn order shall remain stayed till next returnable date, list accordingly.
Obliged. Just one prayer, item 6 may be tagged up with on 14/11.
Let this matter be listed along with FAO number 58/2025 on the next date fixed.
Obliged.
Yes. What is this?
I filed one title suit against the respondents. And
You are the
in-
plaintiff.
I'm the plaintiff. What happened in this case? I filed one application for calling of the MSNJ case reports. On account of my fault, the steps could not be taken. My prayer was rejected. Thereafter,
Rightly rejected.
Thereafter, I filed one application for allowing me to submit the certified copies of the Miss NJK's reports,
Okay,
and that was rejected, for which I have done this.
okay. What is your submission? That may be allowed, second prayer may be allowed.
Maybe allowed, but my lord, he has made further prayer by additional affidavit that like the learned trial court has rightly rejected the petition. Firstly, he was given an opportunity to call for the
He
report
failed,
because
he
of his
failed to
failure.
take steps.
Because of his failure, that was could not be brought on record. Secondly, my lord, he was given the opportunity for filing the certified copies. Even in the certified copies, what his prayer is that all the certified copies were not ready. So till that, even in the additional affidavit, your lordship kindly peruse, he has made a submission that to that extent, I have no objection if the this honorable court allows that whatever is on record, that is allowed to be bring on evidence, on record as evidence, but not the petitions which are not before the court. And which is saying that that are certain NJ records are about to be received. Because for this, the proceeding cannot be prolonged. My lord, kindly see my objection. The suit was pending since At the-
Where is the impugn order?
impugn order, my lord, will see at page 105. It starts at yes, 105. Annexure 7. The real page 106 will be the relevant portion, my lord, the last paragraph.
Yes.
The defendants filed a written objection whereby the defendants have stated that the petitioner plaintiff clearly depicts that the petitioner is seeking leave to rely upon certified copies of some NJ case records which are not yet fully obtained. Some of the certified copies of NJ case records are not in possession of the plaintiff and are only likely to be received. The petitioner plaintiff stopped from relying upon the documents by certified copies at the stage of relying on certified copies were not available at the proper stage of steps. No case is made out to grant leave to the plaintiff petitioner to allow him to execute the certified copies as case records. Now, upon going through the contents of the petition as well as the earlier orders of the court, it appears that by order dated 7/2/24, the plaintiff was allowed to call for the NJ case records. But on 4/4/24, the plaintiff was directed to take steps even after getting the opportunity to call for the NJ case records at the stage of evidence of PWs. The plaintiff did not avail the opportunity to exhibit the NJ case records in support of his claim, for which he was barred from taking steps for calling the NJ case records. This is the one aspect. Now, again, on 6/5/24, the plaintiff had taken a false claim that the plaintiff side took a step as per order dated 7/2/24 to call for the NJ case records. The claim of taking steps as per order dated 7/2/24 by the plaintiff appeared to be false to my learned predecessor on verification of court fee register, as the court fee register did not reflect about taking of any step for calling a NJ case record. So the conduct of the plaintiff is not at all satisfactory. In the present petition, so and so also the plaintiff has stated that he has received some certified copies of NJ case records and yet to receive some certified copies of NJ case records. The plaintiff has not enclosed any certified copy of NJ case records to substantiate his claim of obtaining some of the certified copies of NJ case records. Moreover, the certified copies of all the NJ case records mentioned in para number 2 of the petition is not ready for submission before the court. So, my lord, this is the status, my lord. And even in the additional affidavit, if your lordship kindly take up the additional affidavit of the petitioner, they have still making this submission that all the case records are not ready.
Only two Miss NJ case reports which were applied long back before filing that application.
My lord,
Two NJ case reports were not received.
may I bring it to the lordship notice? Kindly see.
You are tenant.
I'm telling.
Kindly see their petition, what they have made. Firstly, if your lordship kindly take my objection, my lord, at page 180. Page 179, my lord. Page 179 for a moment. How they are delaying the suit since 22, my lord. Have my lord got to page 179. This is the tracking slip of the
trial court record of the date fixed. Since 31/10/2022, the suit was fixed for steps before preliminary steps. He has got ample opportunity. He knows what is the issues and what evidence he has to lead. And even he did not took any steps for calling for all those NJ records. Only at the stage of when plaintiff witness was made on 4/1/23, the first date for the PW. He did not make any steps. It went on to go on 28/6/24. Page 180, my lord will see. Even thereafter only it was rejected. Now for a moment, your lordship kindly see page 170 of their additional affidavit. In the piecemeal, they are making the application for certified copies. Yes, page 170, it is in respect of one of the NJ case record number 9628. This application was made on 16/5/24. And thereafter, page 171, of the another NJ case record of which my learned friend is speaking of, Miss NJ case 1283 of 22. For this, he has made an application on 19/7. At one go, he has not made even the certified application for the certified copies also. In a piecemeal, taking time after time, he is making this dilatory tactics, my lord. Since 22, he knows what is his case, what evidence he has to lead, and we are into 25. For three years, he has dragged the matter, my lord, for calling for relying upon even the certified copies. This is the
Yes.
conduct, my lord.
Where is the error in the impugned order?
My contention is that for the fault of the advocate, the client's litigant should not be suffered. I have applied the certified copy on 16/5/24. And two NJ case reports which were, the certified copy application was submitted before this annual court, which were although filed, but those applications were not found at the stage, and thereafter the subsequently that was applied on 16/5/24.
On 65, only one NJ case record was called for, my lord, was applied for.
And 19/7.
29/7.
19/7.
No. My query is, this is an application under 227, Article 227. Have you made out a case for invoking 227? Where is the error in?
My lord, the requirement of this law is that the documents which were not filed at the time of the filing of the suit may be brought in record subsequently with the leave of the court. I sought the leave.
But
That
the
was-
documents are not still with you, which you,
I have applied, my part is that I can apply and submit the requisite court fee and document, folios. But when the reports were not available.
no, but
Not found.
you know that you have to defend a case. So you cannot apply in piecemeal manner.
I applied at the earlier stage. One application was not filed at that stage because due to some mistake that was subsequently filed before passing of the order.
At what stage the
The
suit
stage
is pending?
It is, my lord. It is for DW.
There is no stay.
Not DW. The order from this.
This is, there is a, it's due to pendency, yes, only the.
Pendency of this.
Is there any stay?
No stay, there was no stay. The trial court has fixed the matter. From order of.
Otherwise, his PW just closed by rejecting that.
I'll pass orders next week. Heard Mr. S. R.K. Moore, learned counsel for the petitioner. This is item number.
8.
Also heard Mr. G. Jalan, learned counsel for both the respondents. Hearing concluded, judgment reserved. Wait till next week.
May please on judgment of the.
You Mark the paragraph on which you are relying. Next month.
Item 9.
Yes, it was mentioned. What is your prayer?
Matter be adjourned for the day, due to some personal inconvenience of the engaged counsel. She is not able to appear before this court premises.
But if, we have no objection to that effect. But if, I have submitted that since, TCR has already reached the court, so matter may be admitted, and in due course, and we may be allowed to issue.
Okay. Heard, what is your name?
BP Sharma.
Heard Mr. BP Sharma, learned counsel for the petitioner. Also heard Miss
As thus, on behalf of P. Mishra.
S. Das. Appearing on behalf of Miss P. Mishra, learned counsel for the respondent number 4. Learned counsel for respondent number 4 prays for an adjournment on the ground of personal difficulty of the conducting counsel for the respondent. However, since this matter is listed for admission and this court finds it fit to admit this matter for hearing, this matter is admitted for hearing and admitted for hearing. Stop. List this matter for hearing when?
What's the matter may be fixed on after 1 week?
After 2 weeks on a date to be fixed by registry.
Ten.
During this case, the landlord tenant suit, my lord. Here, the suit was dismissed of the plaintiff landlord and the defendant tenant, my lord. And in the appeal, it was reversed. And suit was dismissed by the landed tribunal both on the ground of bona fide requirement as well as defaulter. But the landed appellate court, my lord, has reversed the finding as to bona fide requirement, which is contrary to evidence on record. And that is the perversity. On the ground of perversity, we have challenged that order, my lord. And in fact, my lord, yesterday we have filed one additional affidavit to bring on record the deposition of the plaintiff PW1, my lord.
Whether that is on record?
That has not come on record, my lord. That has not come on.
Yes,
So
let that be on
make it
record.
come up on 23rd, my lord, and after this.
Heard Mr. G. Jalan, learned counsel for the petitioners. Also heard Mr. J.H. Soikia, learned counsel for respondent.
My senior's name may kindly be recorded. Mr. S.
But he is not before this court. Why should I record his name?
Although my lord, he is leading me.
Today he is not before this court.
All right.
Mr. J. Saikia, learned counsel for the respondent. Learned counsel for the petitioner has submitted that the petitioner has filed an additional affidavit in this case to bring on record the deposition of witnesses adduced.
PW1 only.
Deposition of PW1 adduced before the trial court. However, same is not found on record. The registry is directed to place the said additional affidavit on record and list this matter again on no fixed date.
20th
My lord,
or 27th, my lord.
it may kindly be fixed, my lord. That's because it is a tenancy at my lord.
Yes, on
23rd of
27th. On 27th of October.
This is your fifth
This is the MSc appeal lordship against the judgment dated 7/7/25. Lordship, basically, the contention is that the court has court came to a finding that there was violation of policy condition. Court gave a pay and recovery order. Whereas as per the new provision, there is no such case, and the other ground is that, about interest lordship, and then the two vehicles were involved, so head-on collision, that is another ground lordship. And also the interest during COVID period lordship.
Last one is
Interest during COVID period as per Apex Court order lordship, that period from 15/3/2020 to 2/10/2021, no interest is to be given, but the court has not followed. Those are the grounds.
there is a judgment. Apex Court. Okay.
F-
Heard Miss
yeah.
R D Majumdar, learned counsel for the appellant insurance company. Come on, stop. This appeal under section 173 of the Motor Vehicles Act 1988 has been filed by the appellant insurance company, impugning the judgment and award dated 7/7/2025, passed by the Motor Accident Claims Tribunal number 1, Kamrup within bracket Metro, Guwahati, in MSC case number 616/2021, whereby the appellant was directed to pay a compensation amount of rupees 18,46,700 to the claimants, along with an interest at the rate of 6% per annum till from the date of filing of the claim petition till realization. This appeal is admitted. Let the records of the MSC case number 616/2021 be requisitioned from the concerned Motor Accident Claims Tribunal, the registry to take steps for requisitioning the aforesaid record. Let also the notices be issued to the respondents. The appellant shall take steps for issuance of notice upon the respondents by registered post with AD as well as by usual mode.
At this moment, lordship, if they do not appear, then next time we can take usual process.
Registered post by AD within 7 days from the date of this order, returnable after 4 weeks, list accordingly.
Lordship, there is a IA 3298 of 2025. For stay, lordship.
I will be issuing notice.
So we can deposit 50%, but withdrawal may not be allowed at this moment. Later on, if they come and they pray for the file a IA, then they can withdraw. We can deposit 50% at this time, at this moment.
Heard Miss R D Majumdar, learned counsel for the applicant. This application has been filed by the insurance company / appellant in connection with MSC appeal number 446/2025. Praying for stay of execution of the judgment and award dated 7/7/2025, passed by learned member Motor Accident Claims Tribunal number 1, Kamrup Metro at Guwahati in MSC case number 616/2021. Since learned counsel for the applicant has submitted that the applicant is ready to deposit 50% of the awarded amount as a condition for staying the execution of the said award, this court dispense with the notice to the opposite parties and allows the instant interlocutory application. The judgment and order dated 7/7/2025 passed by the Motor Accident Claims Tribunal number 1 Kamrup Metro in MAC case number 616/2021 is hereby stayed. The execution of judgment and order is hereby stayed till during the pendency of the connected MAC case number, MAC appeal number 466/2025, subject to the condition that the applicant/appellant shall deposit 50% of the awarded amount to the registry of this court within a period of
6 weeks.
6 weeks from the date of this order. This interlocutory application is accordingly disposed of.
Without any, if in the earlier part, can it be added, Lordship? I'm ready to deposit, but no withdrawal, Lordship.
No, before withdrawal, they will seek leave. And when they seek leave,
No,
you,
no. That we will deposit, but without.
there is no direction for withdrawal.
That
And
is
automatic withdrawal cannot be done without leave of this court. So they will appear before this court seeking leave, then you may object.
No, not about that, Lordship. My submission, Lordship wrote that I submitted that we are ready to deposit.
Okay,
In that part, Lordship, not Lordship's part, in my part, earlier part.
Submissions of the council that since production, since
First part.
subject to the condition that same may not be withdrawn by the claimant without leave of this court.
Highly obliged.
Hearing under order 41-2, item 13.
In this case, my lord, I have received the instruction on affidavit, my lord. They allow to withdraw the appeal, my lord.
Okay, good news for you. Heard. Mr. K.R. Padgiri, learned counsel for the appellant. Also heard Mr. S. Deka, learned counsel appearing for respondent number 1 to 7. Learned counsel for the appellant has submitted that he has received instructions on affidavit, instructions from the appellant to withdraw the instant regular second appeal, and accordingly he seeks leave of this court to do so. In support of his submission, he has furnished an affidavit sworn in by the appellant, namely Shri Hanta Buragohai, wherein it is stated that the appellant no longer intends to pursue the instant regular second appeal. Stop. Considering the submissions made by learned counsel for the appellant, the prayer is allowed. This appeal is dismissed on withdrawal. Let the affidavit furnished by the learned counsel for the appellant be marked as X and be kept in the record of the instant appeal as a part of it.
Obliged.
In view of the disposal of the RSA on withdrawal, the interlocutory application stand disposed of.
Obliged.
Item 16.
Lord, I am extremely sorry, my lord. The file has been given to me right now only, my lord. Next week, I need it, my lord. After 1 week, my lord, I have to prepare, my lord.
Heard Mr. A. Khanikar, learned counsel for the appellant who seeks an adjournment as he has received the brief of this case today only and needs some time to go through the same. Considering the submissions made by learned counsel, the prayer is allowed. Prayer for adjournment is allowed. Let this matter be listed after a week on a date to be fixed by registry.
Deep level.
Item 17.
Your lordship, in this case, we are supposed to file substitution petition, but we are not received the list of the legal heirs today, lordship.
So what is your prayer?
Supply those details of the respondent.
Okay. Heard Miss A. Das, learned counsel for the appellants. Also heard Mr.
Yes, sir.
A. Sharma, learned counsel for the
Appearing all the respondents.
respondents. Learned counsel for the appellants has submitted that the appellants could not file application for substitution of the legal heirs of the deceased respondent, as the list of legal heirs has not yet been furnished to them. Stop. On this, learned counsel for the respondent submits that he will be furnishing the said list during the course of the day. In view of the submissions made by learned counsel for the parties, this regular second appeal is adjourned for the day. Let this be listed after
Fix a
2.
date, lordship. The 2012 matter, lordship. People are, respondents are dying, lordship. Any date, lordship. Lordship may fix it.
After 2 weeks on a date to be fixed by registry.
Lordship may fix it, lordship.
I'm fixing a date, but burdening the registry to do so. Otherwise, my list will get messed up.
Obliged. 19.
Your lordship, these are analogous matters. On the last date, service was not complete on R2 and R3, and we were instructed to file substitution petition for R2 and ascertain the address of R3. However, your lordship, the company has not been able to locate R2 and R3, and as such, I pray for some more time, your lordship, because they are necessary parties, they are owner and driver of the other vehicle, your lordship.
Yes,
Lordship, I am appearing for respond number 4,
in both the cases.
in both the cases.
Heard Miss, what is her
A.
name?
Biani.
A. Biani, learned counsel for the appellant. Also heard Miss M. Chaudhary, appearing for respondent number 4. Learned counsel for the appellant submits that as the appellant could not yet locate the proper address of respondent number 2 and respondent number 3. Fresh.
Your lordship, address of respondent number 3, and for R2, we need to find out the legal heirs of R2.
Proper address of respondent number 3, as well as list of legal heirs of respondent number 2, comma. Hence, the substitution petition for substituting the legal heirs of respondent number 2 could not be taken, could not be filed. Moreover, fresh steps for issuance of notice upon respondent number 3 also could not be taken due to unavailability of the proper address. She seeks some time to get the same and take appropriate steps. Stop. Learned counsel for respondent number 4 does not have any objection to the said prayer. Hence, the prayer is allowed. Let this matter be listed
After 4 weeks.
after 4 weeks.
Not applied.
20.
May I please, your lordship? Lordship, I'm sorry, lordship, lordship matter may be fixed on either lordship 4th or 6th of November, lordship, first week of November, lordship.
Why?
Lordship, lordship, there is some problem, lordship, personal problem of me, lordship.
Heard Mr. What is your name?
Yes, sir.
Heard Mr. S. Ali, learned counsel for the petitioner who seeks an adjournment on the ground of personal difficulties. Stop. None has appeared for the respondent. You are appearing for respondent.
Lordship, I have for item 1 and 3,
What is your name?
J.A. Sikdar.
Mr. J.A. Sikdar is present. What is your submission on his prayer for adjournment? You are opposing? Mr. J.A. Sikdar, learned counsel for respondent number 1 and 3, does not oppose this prayer for adjournment. Hence, the prayer is allowed. Let this matter be listed.
That 4 or what, 6, Lordship?
No fixed date. On in the second week of November, on a date to be fixed by registry.
May it pleases your Lordship. Your Lordship, in this revision petition, I am appearing for both the respondents. So service is complete.
My lord, during pendency of this revision petition, a settlement between the parties took place on 4th of September.
Took place already.
Yes, took place, but an execution proceeding is continued between the parties in the Court of Learned Civil Judge Junior Division, Buxa. So in the meantime, till any further proceeding be completed in logical conclusion, this matter may be adjourned for after 4 weeks.
My lord, I have not been informed regarding any
Execution.
compromise that has been taken place, but the execution has been stayed by the last order of this honorable court.
Yes.
And moreover, what has happened, your Lordship, they have preferred a CRP here, revision petition, while the revision petition will not lie, a second appeal will lie, because they are challenging the judgment and decree of the first appellate court before this court in a 227 proceeding.
That is the matter of merit, my lord.
And there is no compromise as such. I have not been informed any compromise. Lordship, I pray that as there is a stay of the execution proceeding,
Yes.
this matter may be fixed after 1 week for admission hearing and the matter will be dealt.
No, you take instructions.
I will take instruction in the meeting.
whether-
Proper instruction.
I will take
Whether
instruction.
there is, heard Mr. A. Paul, learned counsel for the petitioners, also heard Mr.
AI Ahmed.
A.I. Ahmed appearing for both the respondents. It is submitted by learned counsel for the petitioner that an effort of reaching an amicable settlement between the parties is going on. And there is likelihood of this matter being settled amicably between the parties, and therefore prays for listing this matter after 4 weeks. On the other hand, learned counsel for the respondent submits that he is not aware, neither he has been instructed by the respondent regarding any amicable settlement which is regarding pendency of any effort for amicable settlement between the parties. And he submits that since a stay of execution case is operative in this case, the case may be listed after a week. After considering the submissions made by learned counsel for parties, we list it after 3 weeks. The prayer for adjournment is allowed. Let this matter be listed after 3 weeks.
Deeply obliged.
The interim order shall continue till next day.
And in the event of my lord settlement, final settlement, we may be allowed to file an affidavit.
There is no bar that need not to be reflected. You have to inform this court.
Okay.
Deeply obliged. May I please, Your Lord? The matter relates to the transfer petition filed by your wife, husband at Dibrugarh, which is, and the wife is before your lordship who transfer it at Tezpur, since she is from Tezpur, my lord, and she has no means of livelihood to stay at Dibrugarh also. That's why,
Yes.
my lord, there is a stay order. I hope if your lordship can consider it, we want amicable settlement also, the matter maybe. And husband has also given a proposal for amicable settlement also. That can be done. So let him come to Tezpur, my lord. Let the matter be transferred to Tezpur, my lord.
Yes.
We don't have any objection if the matter is transferred, spread by petition.
What is the matter? What case is sought to be transferred to trust?
Divorce matter, divorce.
Divorce case? The Tejpur court has jurisdiction.
Oh, jurisdiction, but it can be, on the intervention of the court, it can be transferred for the convenience of the wife.
No, but the Tejpur court does not have jurisdiction.
But my lord, if your lordship send it to Tejpur, then the jurisdiction will come.
Show me the
And it-
authority that it can be transferred
It will
to
come next week,
a court without jurisdiction.
next week. I will give you coordinate bench judgment also of the,
Not court, okay.
so many cases, man.
You come up with a ruling. Heard Mr. D. Bishwas, learned counsel for the, heard Mr. S. C. Bishwas, learned counsel for the petitioner. Also heard Mr. K. Kolita, learned counsel for the respondent. Learned counsel for the petitioner has submitted that this instant transfer petition has been filed by the petitioner, Srimati Jharna Bania, for seeking transfer of
Divorce case, my lord.
what
Filed
is
at Dibrugarh.
what is the case number?
I'm giving
Transfer of title suit within bracket divorce
113 of
number
20.
113/2023 pending before the court of London, additional district judge within bracket FTC, Dibrugarh
Dibrugarh.
to the court of London, district judge Sonitpur at Tejpur. Learned counsel for the respondent submits that the respondent does not have any objection if the petition, if the prayer made by the petitioner is allowed by this court. Stop. On this, a query was posed to the learned counsel for the petitioner by this court as to whether the court at Tejpur would is having jurisdiction to entertain the said divorce petition. Stop. Learned counsel for the petitioner answered the same in negative. However, he submits that when the parties are agreeable, the transfer can be made even to a court which does not have jurisdiction to entertain the matter, and he seeks leave of this court. He seeks some time to produce authority in support of his submissions. The prayer is allowed. Let this matter be listed when
Next week, any date? Or convenient of the court. Of October.
October.
Development.
Let this case be listed on 28th of October.
Chief, this is the spell matter, transfer matter, madam. And filing this petition from the transfer of the divorce matter from Udalguri to Guwahati, madam, principal. The lady is living in Guwahati, madam. She is the sole living lady, madam, living with her mother.
Lordship, this matter has already become infrastructure as a district. Judge has already passed an order relating to this case. The case has been dismissed. This is the order copy.
Who is the? It is a divorce case
Yes,
filed by you.
no lordship, another advocate at the district court.
No. Husband filed by the husband.
Yes, yes.
Filed by the husband, your wife.
No,
I'm
lordship.
the wife.
Is the
Your-
I'm
your
for
wife.
I'm for the husband.
Your husband. Husband filed the divorce case, which has been dismissed. Then it has become infructuous. Heard Mr. P. Soikia, learned counsel for the petitioner. Also heard Mr. What is your name?
W Akhtar on behalf of K Sinha.
W. Akhtar, appearing on behalf of K. Sinha, who submits that though this transfer petition was filed by the petitioner for transferring the title suit divorce number 37/2023 from the Court of Learned District Judge Udalguri to the any court of competent jurisdiction in the district of Kamrup Metro. However, he submits that by order, by judgment date, by ex parte judgment dated 31/7/2024, the learned District Judge Udalguri has dismissed the said title suit, and hence this instant transfer petition has become infructuous. In support of his submission, he has furnished the certified copies of the judgment dated 31/7/2024 passed by learned District Judge Udalguri in title suit within M number 37/2023. Stop. I have perused the same. Stop. It appears that the said title suit has been dismissed by the District Judge Udalguri by the aforesaid judgment. Stop. Hence, this transfer petition has become infructuous, and accordingly same is disposed of on becoming infructuous.
Item 54.
Both the parties, they have appeared, responded appeared, so matter will go down to admission.
Okay. Heard Mr. H. Sharma, learned counsel for the petitioner. Also heard Mr. M.
MP. South.
Yes, MP Sharma, learned counsel for respondent number, both the respondents.
That's one number.
How many respondents are there?
Only.
Learned counsel for this whole respondent. It will go for hearing.
We'll go for admission. It will fix for admission after 3 weeks. Preparation has to be
Stop.
done.
Records are record.
Records are also
Records would be necessary.
necessary.
What has been impugned?
It is a ejectment suit, so record will be necessary.
The final judgment.
Final judgment.
Okay.
Records will be required. Check the record.
Why records would be, this is a revision petition.
My lord,
What is your ground?
my lord, it is against final judgment.
Final judgment, but this is a revision, we will not go into evidence.
Sometimes that it may be required, man. Evidence whether sometimes it may be required to be considered whether the findings are without going to the new court, without any
Learned-
findings are perverse findings, that has to be seen, my lord.
The ground of perversity has been taken. Learned counsel for the petitioner submits that the records of the trial court and first appellate court may be necessary for adjudication of the instant revision petition. Hence, call for the records of title appeal number 56/2016 from the appellate court, as well as records of title suit number 96/2007 from the trial court. Registry to take steps for requisitioning the said records. List this matter after 3 weeks after receipt of the aforesaid records.
It may be. Interim may continue, madam. There is interim, madam.
The interim order shall continue. Yes.
Wait, in this case, I have been newly engaged in this case on behalf of the petition. So the earlier occasion, notice was issued, returnable within 4 weeks. Now the matter, the serviceable CID parties have appeared. It can be listed for admission.
I'm appealing for respondent number 3, madam. I've already submitted my affidavit in opposition long back.
Admission or nothing. This is,
Mr. Khatonia, your name
yes,
is not
only
shown.
yesterday I have appeared. We have filed on my yesterday. only. Earlier, different set of.
Heard Mr. P. Khatonia. Yes. Heard Mr. P. Khatonia, learned counsel for the petitioner. Also heard Miss, what is her name? Miss S. Patwari, who was earlier engaged by the petitioner in this case. She submits that the petitioner has entrusted this matter to Mr. P. Khatonia, and therefore the earlier engaged counsel, namely Mr. A. Dhar, Mr. R. Singha, Ms. S. Patwari, may be
Deleted.
allowed to withdraw from this case, and their name need not to be shown in the cause list.
And order.
She has also furnished a written application wherein there no objection is reflected if their names are strike out from this case. The prayer is allowed. The names of Mr. A. Dhar, Mr. R. Sinha, and Miss S. Patwari need not to be names of Mr. So-and-so shall not be reflected as engaged counsel of the petitioner in the cause list henceforth. Also heard Mr. A. K. Jain, learned counsel appearing for respondent number 3, who submits that the respondent number 3 has already filed his affidavit in opposition. Stop. Also heard Mr. N. Bhuya appearing in behalf of Mr. M. Kashyap, learned counsel for respondent number 1 and 2. It is submitted at bar that all the respondents have appeared, and hence this matter may be listed for admission hearing. Admission hearing or hearing?
Final
It should
hearing.
be, actually notice was issued, so it will come for admission.
For admission hearing.
Yeah.
The prayer is allowed. Let this matter be listed in admission column after 2 weeks on the date to be fixed by registry.
Award name.
The registry is also directed to reflect the name of Mr. P. Khatuniar as engaged counsel for the petitioner in the cause list henceforth. Mr. P. Khatuniar and Mr. N. Sharma as engaged counsel for N. Sharma and B.K. Sinha as engaged counsel for the petitioner in the cause list henceforth.
The interim order, earlier interim order.
The interim order shall continue till next day.
Right, please, Lordship. Lordship, kindly peruse the office note dated 8/10/25, my lord. Respondent number 1 and 4 has been duly represented by filing Wakalnama, my lord. And answer notice on respondent number 2 and 3 received back, my lord, with illegible postal remark.
What
And,
is to be done?
my lord, again take fresh steps on respondent number 2, 3, 5 and 6, my lord. And it is already taken, my lord, in connected appeal, my lord. Yesterday, my lord.
Okay.
It already,
But here you have to take separately. Heard Miss L. Sharma, learned counsel for the appellant. Also heard Mr. L. R. Majumdar appearing for respondent number 1, as well as Mr. R. D. Majumdar appearing for respondent number 4. The office note dated 8/10/2025 shows that the notices issued to respondent number 2 and 4, 2 and 3, as well as respondent number 6 has returned back without service. Stop. In view of the above, the appellant is directed to take fresh steps for issuance of notice upon respondent number
3, 5 and 6. my
2,
lord.
3, 5 and 6. Again, by a registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks.
LCR received, my lord, and this matter may be tagged with MSC appeal number 190/2024.
Let this matter be listed along with MSC appeal number
190/2024.
190/2024 on the next date fixed.
Oblige me.
Item 27.
Lordship, this is for confirmation of delay. 8 days delay in filing appeal, Lordship.
How many?
8 days. My friend is appealing for claimants.
Any objection?
Claimants, Your Lordship. Respondent number 1, 2 and 3. No objection, Your Lordship, no objection.
Heard Mr. R. Sharma, learned counsel for the applicant. Also heard Mr. A. N. Iqbal appearing for respondent number 1, 2 and 3. This interlocutory application. No, sorry. This interlocutory application under Section 5 of the Limitation Act 1963 has been filed by the applicant for condoning the delay of 8 days in preferring the connected appeal, whereby the applicant has impugned the judgment and award dated 5/10/2023 passed by learned member, motor accident claims tribunal number 2, Kamrup Metro, in MSC case number 2406/2018. Learned counsel for the applicant has submitted that the applicant has stated the reasons for delay in paragraph number
3 and 4, Lordship.
3 and 4 of the instant condonation application. Stop. Learned. On the other hand, learned counsel for the respondent has submitted that considering the grounds shown by the applicant in the condonation of delay application, he has no objection if the prayer for condoning the delays allowed. Stop. Considering the grounds taken by the applicant in paragraph number 3 and 4 of the application to be sufficient cause which prevented the applicant in approaching this court for preferring the connected appeal within the period of limitation, as well as considering the fact that learned counsel for respondent number 1, 2, and 3 has no objection if the prayer of the applicant is allowed, comma, the delay of 8 days in preferring the connected MAC appeal is hereby condoned and this interlocutory application is allowed. Stop. Registry is directed to register the connected MAC appeal and list the same for admission in the next week on a date to be fixed by it.
Deeply applied, Lordship.
Item 28. Notice was issued, service complete, matter come for admission hearing.
Heard Mr. N.K. Kalita, learned counsel for the petitioner. Also heard Mr. T.
R.K. Sharma on behalf of D. Chaudhary.
Heard also heard Mr. R.K. Sharma. Only one respondent,
Yes, only one.
R.K. Sharma, appearing for the sole respondent. Since the appearance of both the parties is complete, let this matter be listed for admission on a day to be fixed by registry.
Interim order is.
The interim order shall continue till next day.
As per the last office note, respondent number 1 has already filed the Vakaltnama. Service is
Okay.
awaited on respondent number 2 and 3.
My lord, respondent number 1 is the main respondent, others are performer respondent, my lord, and I was the plaintiff, my lord. So unnecessary, my lord, its suit is pending since 2014, my lord.
Main case, though. CRP. What for this IAS?
It's against an interlocutory order, my lord.
It's for the interim, it's for an interim order.
2364. What for IAS file?
For interim order, Lordship.
But interim order is granted in the, okay, common order has been passed.
The time of issuing notice, my lord, interim order was not there, so they have filed this IA, my lord.
Heard
The
miss
matter may come up for
Give her a
admission,
check.
for admission,
my lord.
but other two,
And for respondent number 4 also, Lordship, proper address, it's, the office note reflects there is insufficient address. So we may be afforded some time
Don't think, my
to
lord,
file the
others are,
proper address.
because when the respondent number 1 is the, my lord, main respondent, others are performer. Performer respondent, and I was the plaintiff, my lord, sole plaintiff, my lord, of the suit, my lord. Against filing a document, my lord, they have come against that order, my lord, which the document filed by the plaintiff along with the evidence, my lord. Against that, my lord, they have filed this revision petition, my lord. So others are unnecessary, my lord, pending, my lord. Already, my lord, suit is filed.
what
in
is
the-
your submission? No, but then we will vacate this stay. We'll grant you time. What will happen to the notice to other sides?
Same on the- Lordship, I have to obtain instructions from my senior regarding that.
Heard Ms. K. Bhattacharya, London counsel for the applicant, Also, Mr.
P. Sundi.
Also, Mr.
P. Sundi.
P. Sundi, appearing for
Respondent number one.
appearing for
Main
respondent
respondent.
number 1/plaintiff. The office note dated 29/7/2025 shows that the notice issued to respondent number 4 has returned without service, whereas AD card in respect of respondent number 3 has returned with signatures of the respondent. And in respect of respondent number 2, the unserved notice have not yet been returned. So in view of the office note, the notice is held to be duly served on respondent number 3. Stopped. As regards respondent number 4 and 2, learned counsel for respondent number 1 has submitted that as the respondent number 1 is the plaintiff in the suit, in the title suit number 72, and why this CRP was preferred?
Next page number 68.
What is that order?
Was against, they want to file a.
My lord, actually, we have filed in my lord affidavit, my lord, exhibiting a sale deed, my lord. Now they've challenged that, my lord, we have not taken leave to file that, my lord. We have, yes, my lord. We have laid a secondary evidence, my lord.
Learned counsel for respondent number 1 has submitted that since this revision petition has impugned the order dated
11/9/2024.
11/9/2024 passed by the trial court in title suit number 72, number 2014, whereby the respondent number 1/plaintiff was allowed to produce certified copy.
Yes, ma'am. Certified copy of the sale deed and secondary evidence.
Allowed to produce certified copy of the sale deed number 1173/1961. Hence, he submits that the respondent number 2 and 4, the presence of respondent number 2 and 4
Respondent.
may not be necessary for adjudication of the instant civil revision petition, and hence pray for dispensing with their presence in this case. I have considered the submissions made by learned counsel for both sides and have gone through the records. Considering the submission of learned counsel for the respondent number 1, the notice to respondent number 2 and 4 is hereby waived. Let this matter be listed for admission.
11th of November.
Second week of
November, 11th of November.
In the second week of November on a date to be fixed by registry. The interim order shall continue till then.
No problem.
My lord, I think 50 supplementary list. I have informed the other part. Twice I have informed.
Okay,
In the cause list, his name is also reflected.
okay, we'll take it up. After some time at 2:30. You have informed, whom you have informed?
MSA
Okay, we'll take it up
by junior.
at 2:30. 2:30, you may inform him that it will be taken up at 2:30.
Already twice he has been informed.
At what time? What has been informed?
That matter will be taken at 2 PM in court number 6. So
2
that
PM.
is 16, sorry, 16.
Okay, we'll take it up at 2:30.
Item 6 at 2, item 47.
I've been engaged today, my lord. Received the copy 3 hours back, my lord. Okay, we are there.
Now, you are ready for hearing or not?
No, my lord.
Why no? You are caveator.
Yes, my lord, because Wakalatnama has not been filed till now. So, my lord, tomorrow, my lord, I can also receive instructions.
No, there is nothing in this matter now.
Yes, my
The
lord, already.
date of the meeting has lapsed. So that his submission is that your suit has become infructuous.
The pair is very specific, 21/9, not saying any date thereafter.
My lord,
If that being so, my lord, it may be covered, but it's very specific, 21/9.
Yes.
my lord, give me some time, my lord, tomorrow.
Okay, let us give him 1 day. Heard Mr. B. Datta, learned senior counsel assisted by Mr. S. Deka, learned counsel for the petitioner. Also heard Mr. D. Bakshi.
My lord may fix a time because
We'll take it up.
tomorrow it is a hearing day, so.
We'll take it up at 2. 2. Learned counsel for the caveator / respondent submits that he has been engaged in this case today only, and he needs some time to go through the revision petition and make his submission. Considering the submissions made by learned counsel for the respondent, the prayer is allowed. Let this matter be listed again on 16th October at 2 PM as a fixed item.
Clear, grateful.
Mr. Mahmood, wait till 2:30.
Yes, now.
We'll take it up at 2:30.
I'm for a respondent lordship. In this case, sir, I have an additional affidavit that was not tagged with the record.
I have not received any copy, my lord. Copy has not served me.
Heard Mr. R. Sharma, let it be. What is the case? Transfer?
Yes.
You are contesting
That's it.
your wife or husband?
Wife. Earlier, my lord, one case has already been disposed of in the, my lord, Lakhimpur, my lord. The husband has contested, my lord. Now, during the pendency of that suit, my lord, the husband filed, my lord, suit in the family court, my lord. That, my lord, I want to transfer, my lord, to the court of district judge.
To Lakhimpur?
Right.
Where do you stay?
Lakhimpur. He's in Guwahati.
It will come after 1 week, lordship.
Okay. This is the
For
item.
admission, my lord.
For admission, it may come.
Okay, item number?
And 30.
30.
Heard Mr. R. Sharma, learned counsel for the petitioner. Also heard Mr. A. Sharma, learned counsel for the respondent, who submits that respondent has filed an affidavit in opposition.
An additional affidavit.
An additional affidavit in this case, which has not tagged with the record yet. Stop. The registry is directed to tag the additional affidavit filed by the respondent with the record and list this matter in the next week on a date to be fixed by it. Next week on a date to be fixed by registry.
In the admission column. my lord.
In the admission column.
I have copy, my lord, of the
I will
additional.
have, lordship. I will have a copy.
The counsel for respondent is requested to furnish a copy of additional affidavit to the learned counsel for the petitioner.
Bless.
41.
Yes,
Service is copy, suffer admission.
no, I could not get you.
Yes, sir. Service is compared, the respondent stand up. So matter it is for admission.
Okay.
Lordship, the matter, Lordship, this petition, Lordship, is an abuse of process of the law, Lordship. Abuse of wastage of judicial time, Lordship.
What is the matter?
Kindly, page number 51. The order?
Is there any stay?
Oh, no, Lordship.
If stay is not there, we'll fix it in the admission column next week. We'll dispose it of then.
Yes, sir.
It has come up in orders column. Heard Mr. B.J. Ghosh, learned, heard Mr. D. learned counsel for the petitioner. Also heard Ms. M. Chaudhary, learned counsel appearing for the sole respondent. Since the appearance of party is complete in this case, let this matter be listed for admission.
Can it be, Lordship, on 23rd, Lordship?
Admission in the next week on a date to be fixed by registry. 3 dates are available. Out of 3 days, registry will give.
23rd is not in that 3 days. Lordship.
Why today is 15, 23rd is in the next week. I am not giving a fixed date.
Obliged, Lordship.
In the next week on a date to be fixed by registry.
Obliged.
32.
Please, your lordship. Lordship, as per last order, I have effected dusty service of the service copy upon the respondent. And according to the respondents appeared.
Sole respondent. Heard Mr.
A. Bhuya, I am appearing on behalf of Ms. S. Parveen.
A. Bhuya appearing on behalf of Ms. S. Parveen, learned counsel for the petitioner. Also heard Miss, what is her name? She,
J. Chanda.
J. Chanda, appearing on behalf of Mr. N. Sarkar, learned counsel for the respondent. Since appearance of parties are complete in this, is complete in this case, list this matter for admission on a date to be fixed by registry.
Right.
44.
Yeah, please. It's a petition for condonation of delay, my lord, 93 days, my lord. My lord, earlier the petitioner filed writ petition, my lord, civil writ petition. That petition was withdrawn with liberty to file a fresh, my lord, and directed to file civil revision petition, my lord, instead of writ petition. Thereafter, this civil revision petition filed, my lord. This was some delay, and they also earlier condoned, my lord, that by honorable court. And the civil revision petition, my lord, IA filed. That IA was withdrawn, my lord, under the direction of the registry, my lord, and then fresh CRV filed, my lord. There is, that is why some delay, my lord. They have not.
Where have you explained the delay?
8, 9, 10, 11.
What
There
is
is
the
a-
reason for delay?
Reason, my lord, earlier the petitioner approached by filing a writ petition, my lord. That writ petition was withdrawn with a liberty to file a fresh and in the direction of this honorable court, my lord. Page, my lord, page 15, my lord. Earlier order passed by this honorable court, my lord. Annexure 1, my lord, page 15, my lord. Third, State Civil Learned Council appearing on behalf the petitioner, the instead it petitioner is challenging the order that.
How much is the delay?
93 days, my lord.
Where have you how have you explained delay? What is the
Explain, my
reason?
lord, my lord, 8, paragraph 8, my lord, page 7, my lord. My petition, my lord.
No, in the writ petition order, liberty was granted,
Yes, my lord.
but it does not mean that delay was condoned.
Yes, my lord.
For condonation of delay, you have to, you
Yes,
are
my lord, I have-
opposing or conceding.
Yes, my lord.
For the respondent, your lordship, my senior counsel is not present, your lordship. And
Therefore, you have to make submission. Your senior is not there.
matter may pass over your lordship.
Earlier occasions, so they have taken time. my lord. And they have not file any objection till that, my lord.
We are allowing the petition. Or do you have any objection? You ask your senior and we'll take it up after some time. And if your senior says that there is some objection, come prepared with that objection. You make submission. We'll take it up after some time.
Lordship.
Item 35 and 36.
Wait, please, your lordship. My lord, in this matter,
Whose order? My order.
no, my lord, it's been passed by Honorable Justice Maharashtra Nandi.
Okay. Notice will go. Third, Mr. D. Rathi, London. Counsel for the petitioner. This application for review under section 114 of the CPC, read with section read with order 47, rule 1 of the said code, has been filed by the petitioner seeking review of the judgment and order passed by the judgment and order dated 6/5/2025, passed by a coordinate bench of this court, within bracket Honorable Mrs. Justice Malashri Nandi, since retired, bracket close, in MFA number 110/2013, whereby the appeal was dismissed.
Yes.
Whereby the aforesaid appeal was dismissed. You have served notice on the standing counsel.
Yes, my steps has been taken. Previously, my lord, notice was also issued.
Though name of, this is item number,
35.
the name of Deputy Solicitor General of India has been reflected in the cause list as counsel for respondent. However, none has appeared. What is to be done? What is your submission?
My lord, if your lordship may consider that my learned friend can assist the honorable court, then lordship may fix one final date,
yes.
my lord, give one
Let this matter
last
be,
opportunity.
let this matter be listed after a week, again on a date to be fixed by
My
registry.
lord, if any date, my lord, can be fixed.
No.
October last week, then my lord, if it can be fixed on October.
In the last week of October on a date to be fixed by registry.
Deeply okay.
Common order.
47.
I am appearing for SPI number 1 and 2. Service has completed.
Where is your counsel?
That's
Yeah.
I'm pleading as a petitioner in person.
But you have engaged counsel also.
Yes, the council was absent, that's why I filed my petition to appear as in person.
Okay, what is your submission?
If the impugn order, there is nothing wrong, Lordship. They have prepared this revision petition. Lordship may kindly peruse page 85, Lordship, the impugn order. Both because they have filed
No,
the evidence on affidavit.
No, let us hear the petitioner first. Yes, Mr. Petitioner. Where is the impugn order?
85, page number 85.
Yes. Please read it.
The Learned Counsel for the defendant has submitted that some of the documents submitted as exhibit by the plaintiff have already been submitted before this court, and some of them have been submitted without obtaining the leave of this court, for which they ought not to be admitted. This court, in the interest of speedy trial, deems it fit to mark those documents as exhibits under objection, and the final admissibility of these documents in evidence shall be decided at the time of final disposal of the suit. The plaintiff has submitted evidence on affidavit of PW1 along with service copy to the defendant. Hence, I appoint Learned Commissioner Sri Deepak Kalita to record the cross-examination.
Yes. Now, what is the grievance?
Lordship, as the defendant of this title suit has submitted, that Learned Counsel of defendant has submitted some of the documents submitted as exhibit by the plaintiff have already been submitted before this court. Lordship, I have submitted those documents at the time of presentation of the amended plain, which is the procedure, as well as before framing of issue, on which I relied as evidence. Secondly, it is submitted that some of them have submitted without obtaining leave of this court, which is not true. Page number for this.
No, but court has observed that it will decide the question of admissibility finally.
Yes.
Where is the wrong?
Lordship, the Advocate Commissioner, he conveyed me that he will not allow my evidence during the cross-examination.
Where is that order?
No, he verbally, I asked him, so I communicated as the court told me to communicate with the Advocate Commissioner. I communicated. So I asked whether this objection evidence exhibit will be allowed or not. He told me that this evidence I cannot allow since it is under objection.
No, there is an apex court judgment. You have that judgment, which provides that the documents under objection may be provisionally admitted, subject to final.
Yes, it is written, but the Advocate Commissioner is saying like that. During cross-examination, he cannot allow my evidence under objection.
He's saying will not do. Any order has been passed. We'll clarify that.
Lordship, as the defendant submitted that I have not obtained the leave of the court, it is not true. Page
No,
number.
that is a question of fact.
The page number, so kindly peruse the page number 36, paragraph number 12.
No, you finally convinced the trial court when
Trial court has convinced and allowed me to submit the documents. That's why I'm referring this paragraph number 12 of page number 36.
where is your statement that Advocate Commissioner is objecting? Have you made any statement?
Did not make any statement.
You have made statement in your civil division petition.
Actually, I have given this case to my engaged advocate, but he did not mention it.
This revision is not maintainable. We will clarify that. heard Dr. Manabindra Locker, the petitioner appearing in person. Also heard Mr.
D. Kolita.
D. Kolita appearing for
Respondent number 1 and
respondent number 1 and 2. This application under Article 227 of the Constitution of India has been filed by the petitioner, Dr. Manabindra Locker, impugning the judgment, impugning the order dated 29/4/2025, passed by London Civil Justice Senior Division, Kamrup, Amingaon, entitled suit number 25/2017. Whereby the order of the trial court is in your favor. How you are aggrieved by this order?
Not disagreed of this order. But
Then
as the advocate commissioner is saying, so I.
that you have not mentioned anywhere in the petition. You are impugning the order of the trial court, which is in your favor.
But I afraid, Honorable Lordship,
Stop. The last line ki asil Manu? Stop. For the sake of convenience, impugn order dated 29/4/2025, passed in title suit number 25/2017, is quoted herein below. Quote the impugn order from page 85. Learned counsel for the petitioner has submitted that though he is not aggrieved with the impugn order, however, he has been verbally informed by the advocate commissioner, who has been entrusted to record the cross-examination of plaintiff's witnesses, that those documents which are admitted under objection shall not be allowed to be proved by the plaintiff during cross-examination. Stop. Learned counsel for the respondent, on the other hand, submits that the impugn order has been passed in favor of the present petitioner, and there appears to be no illegality in the impugn order. Before that, counsel for petitioner at the line, learned petitioner in person. Now, the petitioner in person has also submitted that the observation made by the submission made by the counsel for the defendant before the trial court, that no leave was obtained from the court before submitting some of the documents, is not true, in as much as, where is the leave? What you want?
page number 52. There is a court order, Lordship.
Yes. What order?
In the page number 52, it is written that the petitioner of the petition, this is order against amendment petition. Just last paragraph I am reading. The petition of the petitioner is allowed. The plaintiff petitioner is directed to furnish the amended copy of the plaint with the documents within 15 days from today, which I have submitted before the Honorable Court on 26th. That is on the 15th day of this order.
Stop. last name. In as much as the trial court, while allowing the prayer for amendment of the plain by its order dated by its order dated 11/8/2022 had directed the plaintiff within bracket petitioner to furnish an amended copy of the plain with documents within 15 days from the date of the order. Stop. Learned counsel for the the petitioner appearing in person submits that in pursuant to the said order, the plaintiff had submitted the amended copy of the plaint along with annexures on which date you have submitted?
26th.
On 26/8/2022. That is within 15 days of the said order. Stop. Episode Defendants Counsel. Then I have considered the submissions made by learned counsel for both sides and has also gone through the materials available on record. On bare perusal of the impugn order, there appears to be no illegality as the trial court, while passing the impugn order, has clarified that the contentions of the learned counsel for the defendant regarding admissibility of some of the documents may be decided finally at the time of hearing of the suit. Stop. This court finds no irregularity or illegality in the aforesaid observation. Stop. It also appears that by the impugn order, the trial court has also found it fit to mark those documents as regards which objection was raised as exhibits under objection. Stop. The submission of the petitioner in person that the Advocate Commissioner has objected to the said observation made by the trial court in the impugned judgment is not acceptable, as inasmuch as the Advocate Commissioner is bound by the observations made by the impugned order in the trial court. Stop. In view of above, this court does not find merit in the instant revision petition, and accordingly same is disposed of with above observations.
There was an interim order also, that has to be vacated. Matter hasn't stayed there.
I is there.
I know.
The interim order whereby the stay was granted on further proceeding of the title suit number 25/2017 pending before the Court of Learned Civil Judge Senior Division Kamrup Amingaon is accordingly vacated.
Obliged.
Obliged.
Updated item 53.
Yes.
May I please?
I am for the respondent number one, madam.
Okay, what is your prayer?
Remaining, my lord, remaining respondents are not served as per office note.
Okay, let us first hear Mr. Mahmood. What is your submission?
Yes, fine.
Notices have been issued, but service is not complete.
But it stays, my lord, still reasonable, that so that time has passed. And now, my lord, today case is fixed in court below. That's why I have some urgency. If your lordship extends the earlier order, then I have no objection, but on merit, I am ready to submit.
My lord, regarding extension of stay, my lord, my submission before your lordship would be pleased to see the order dated 19/8/2025. It was written, it was, the rule was for 4 weeks. Until returnable date, it was stay. So, my lord, now if my learned friend want extension, a miss case is to be filed because time is already over.
Heard Mr. M.U. Mahmood, learned counsel for the petitioner. Also heard Mr. M.A. Sheikh, learned counsel for respondent number one. This on perusal of the office note dated 14/10/2025, it appears that in respect of in respect of the respondent number, in respect of the notices issued to respondent number 2 to 8, the service report has not yet been received. The registry is directed to place the track consignment report of the notices issued to respondent number 2 to 8 through registered post with AD before this court on the next date fixed. That is 14th of November. Stop.
My lord, regarding extension of stay, my lord, I have some submission, my lord. Because, my lord, what happened? A decree was passed by this honorable court in RSA, my lord. Thereafter, the respondent, now petitioner, my lord, approached before your lordship by filing a petition, a review petition before your lordship. Then your lordship directed the respondent that you file appropriate petition.
No.
Before the
Just a minute. একবার production কি stay হয়েছে? No, before that. Stay কথা কোয়া নাই না? Okay. Yes.
Before the executing court, because execution was stated. Execution is the matter before your lordship. So in your lordship directed that you file what you want to say in the review petition before the Honorable High Court. You can very well say these things before the executing court. Accordingly, the respondent, now petitioner before your lordship, filed review petition. That review petition was registered as miss case. When miss case is pending, my lord, miss case was pending and miss case was fixed on 10/3/2025. 10/3/2025, I referring to page 113.
That was in active consideration of the executing court, my lord. Now, my lord, respondent, during pendency of that miscase, filed this present,
Now, what happened to the execution?
that
The decree has,
execution is pending before the court, my lord.
because of
executing
filing of
court,
this miscase.
my lord. And that miscase is pending before that
Which
court.
miscase?
Miscase
Page
is,
number?
miscase number, my lord, 124 of 2025. Your lordship.
Where
would
is
be
the
pleased-
mention?
Yes, my lord. Your lordship would be pleased to see page 86.
81.
Page 86 is the objection I filed before this one.
In this case?
My lord,
Yes, my lord.
before,
My
No,
lord,
no, let him submit. Let him submit.
so my lord, during this miscase, my lord, miscase is filed, my lord, as per direction of the Honorable High Court.
In the review petition.
Yes, my lord.
Okay. This
So,
miscase
my lord,
is
miscase is pending,
pending.
my lord. Miscase is pending and date is fixed on 1/3/2025. I am
1/3
referring to page 113, my lord.
1/3 has gone.
113.
1/3, 1st of March.
Also, 10/3/2025,
That has also lapsed.
my lord. And what happened, my lord? This present civil revision petition IO filed on 14/8/2025. 14/8.
What is the status of miscase now?
Status of miscase, my lord, that is another thing, my lord. Up to order dated 10/3/2025, placed before your lordship.
No,
Up to date order
are
is
you
not.
aware of about the status of miscase now? Whether miscase has been disposed of or it is still pending?
My lord, I am not aware of, but my learned friend placed the half order, not up to date order.
Mr. Mahmood, what is the status of miscase 124?
it is stayed now,
That is,
stayed now because of
Mm.
this.
miscase has been stayed.
Yeah, both the cases, because my lord, I am
Miscase
saying,
has been stayed by which order?
by, as the execution proceeding has been stayed, so this review petition which I have filed as per direction of the Honorable High Court, and also the miscase which was filed before the landed Munship number 1 at Borpeta, both the cases are now pending. What happened, my lord? The decree is a nullity, my lord,
No, no, we are not going into those questions now.
because
No, we are not going. You first answer the query of the
Yes.
court. You obtained a stay on the last order
yes,
by an execution case was stayed.
yes.
What was the necessity of staying execution
Because
case?
my lord, if there is my dwelling house,
No,
if my,
no, before answering that, before making any submission, answer my query. What happened to miscase number 124/2025? It was pending.
124
Miss,
is the review petition which we have filed before the
no,
landed Munship.
this Miss J case number 125,
125, that is
124. Come to page number 86. Annexure 30.
86, that is their objection, right?
Objection, there is a reference to Miss J case number 124. In which case this objection was filed?
124.
The objection was filed in 124 only.
Yes, my lord.
124 of review petition. That is review petition
Review petition before?
before the landed Munship number 1 at Porpeta.
Executing court, my lord.
No, but
Review petition was registered as miscase, my lord. Because, my lord, your lordship, may I?
so
clear
during
one
the
point?
pendency of the review petition,
Yes.
whether execution could have proceeded.
Several dates were there, my lord. No order was passed, and it was the talk of among the lawyers that on the same day, the order would be passed, and then same day order would be executed. And there is dwelling house. And on the other hand, my lord, the decree is a nullity because
one person has died on my lord, let me submit my lord, how the decree has been obtained fraudulently, I will say, person died on 28/2/21.
No, in this civil revision,
But this was not brought to the notice of the Honorable High Court. That is
which order you are impugning? In this,
the Lordship order, High Court's order.
in this case, which is the impugned order?
So in the High Court, we have.
In this petition, my lord, he is challenging the execution case.
No, decree we have challenged. Decree we have challenged because the decree was.
Decree challenged, my lord, may I?
First, let him submit.
My lord,
properly, or so then I
let
will
me
say.
clear, my lord,
This is-
confusion will not do. My lord, he want to say something that a order passed in the RSA, my lord. Review was filed. And against that review, my lord, a order was passed that what you want to say, you file this before the executing court. Before executing court, he filed the petition, my lord, which is 124. And thereafter, what happened, my lord? What has been stated that immediately after passing the order, immediately that will be executed. That is why he filed this civil revision petition. Can it be, my lord?
My lord, let me submit first, my lord. The order of the first, my lord, before the trial court, there is the dispute regarding 1 biga, 2 kata, 10 lesses of land. Where my dwelling houses are there, I am staying with my family. Now, in the trial court, we have won the case. Their suit was dismissed. They filed first appeal, that was also dismissed. Then they came to the Honorable High Court.
We are starting from 1947.
Yes, definitely, because the story court has to understand. So they filed a RSA before the Honorable High Court, and that RSA was disposed upon 30/11/21, page 45. Lordship. But at the time
What
of,
happened in the RSA?
in the RSA, my lord, they got the decree for the first time. They got the decree and the order of the trial court and first appellate court was set aside. Then, my lord, the party came to me and it was discovered that the decree has been obtained against dead persons. That is, one person died on 22/5/21 and another person died on 28/2/21. And the order was passed on 30/11/21. So as per the limitation act, my lord, within 90 days, party should be substituted. So Lordship, kindly see that.
No, which order you are impugning? In this revision application?
Kindly see schedule 120 of the limitation act. Order 20.
21, rule 29.
Order 22, rule 4. So as per provision of order 22, rule 4, the decree is a nullity because it was obtained against dead person. That was not brought due to unknown reason. That was not brought before the Honorable High Court. They neither made the legal representatives of the dead persons as parties. And dead persons of the parties have a right to defend their case. But they did not substitute the person and fraudulently obtained the decree. That was not disclosed. But when it was brought to the notice of the Honorable High Court by way of filing review petition along with IA, High Court said that you say all these things before the court below. Then we went to court below and we filed petition highlighting all this, that the decree has been obtained against dead persons without substituting the legal heirs of those persons. But the learned court, they are kindly, if your lordship kindly call for the records, took various dates, short dates, various dates, no order is passed. When no order was passed, we are in apprehension that we may be evicted because there is a story that one day, on the same day case was dismissed. At Borpara we have instances, and that instance I may bring, same day case was dismissed, same day it was executed. So due to that reason, we have filed this CRP. Now, if your lordship does not stay the matter, so we apprehend that any time. But if we are given adequate time so that we can file appeal or revision as the law permits, then we have no objection. But here, the order is a nullity in the eye of law. Order 22 rule for kindly see what the CPC says. I'm reading well. Order 22 rule 4. Procedure in case of death of one of several defendants or of sole defendant, where one or two or more
No, no,
defendants
Mr.
dies.
Mahmood,
My lord,
you are complicating the matter. You were defendant. You
you will defend, yes.
decree was passed against you.
Decree with the trial court
In the
and
tri-
first appellate court, the case of the respondent number 1 was dismissed.
Plaintiff's case was dismissed.
Both the courts.
But in second appeal,
In RSA,
RSA,
they got a decree.
decree was passed
Both
against.
the orders were set aside.
Yes.
And this matter that the persons have died long back, it was not brought to the notice of the Honorable High Court. So High Court order did not went into this matter. So when it was brought to the notice of the Honorable High Court, then High Court also observed that if a decree has been obtained against that person, that is a nullity. That order is here.
Where is that order?
Yes, I am submitting. Kindly see page 45.
Which para?
Para, my lord. May be seen from page 49, kindly see page 49. Sorry, my lord. I am saying the RSA, but our petition which say we have filed before the Honorable High Court, that petition may be seen. That petition would have said page 66, my lord. Page 66. That was the order of the RSA. Madam, I kindly say operative portion page 67. The learned counsel para 2, 67 para 2. The learned counsel on behalf of the applicant means present petitioner, submitted that prior to the judgment and decree passed by this court on 30/11/21 in RSA number so and so, the respondent number 2312 in RSA number 46/2014 had expired, and as such have filed the review application. He submitted that the judgment and decree passed by this court dated 30/11/21 in RSA number 46/2014 in so far as the respondent number 2, 3 and 12 is a nullity, and as such there cannot be any execution carried thereupon. Taking into account the said submission, this court inquired with the learned counsel appearing on behalf of the applicant that as the learned executing court has the power to decide on all questions relating to execution, discharge and satisfaction of the decree, why an appropriate application has not been filed under section 47 of the Code of Civil Procedure 1908, and in short the court before the learned executing court. The learned counsel appearing on behalf of the applicant submitted that he would file appropriate application before the learned executing court. As the applicant herein would be filing an application under section 47 of the code as submitted by the learned counsel appearing on behalf of
Where
the
is your application under 47?
applicant.
Where is your application?
Yes, that has been filed before the court below.
Where is?
And here we have
81 page.
here we have also annexed.
Page 81.
81. No, this is the miscase filed another, this is not, but our case, just review petition which we have filed, that is in page 71, 70. Now the grounds, Lordship may kindly see page 74. On what grounds they have filed this review petition, page 74. This is the law, my lord. The law cannot be changed. Kindly see, the first thing is this, my lord, their petition itself was wrong. Because they said that I have purchased 1 bigha 2 gatha, 10 less of land, but they have sought partition
No, this review petition is pending.
pending.
During pendency of this review petition, the execution cannot be completed.
Yes.
Execution will automatically remain stayed
State.
during the
Thing
pendency
is
of the.
this, fellow, so several days can, if, that's why I have invited your lordship. Kindly call for the lower court record. Several dates have been given, but no order is passed. So we apprehended that in some cases,
What's
same
that?
day order was passed. Same day execution has been done. All are this part, I don't know, I am not saying about this case. So we have filed this, that
No, whether hearing took place in the review petition.
hearing took place twice well, but no order is passed.
What is the next date fixed
Next date. Today is the date fixed.
for
Necessary order.
in review petition?
Both the cases, review as well as miss case. Review is registered as miss case.
That is the miss case 124.
Two miss cases are there. One was filed earlier and another has been passed after order of the High Court. So both the two cases are fixed today in Borpeta Munship number 1's court for necessary order. Our submission is this, my lord. If your lordship directs the learned court below to dispose of the case, and till such disposal, no execution proceeding may be started. And if even those petitions are dismissed, but adequate opportunity should be given to the party to file the recourse, to take the recourse of law. That is legal and bona fide submission.
My lord, may I submit one thing? My learned friend want to eat the cake from both sides. Your lordship.
No, let the other respondent
My lord,
appear.
my humble submission before your lordship. They came before your lordship, filing a review petition. Your lordship asked him that whether you have filed any petition under section 47. Then my learned
Under
friend
order
said, order 47. Then my learned friend said, yes, I will file appropriate petition. But your lordship has already gone through. He will file appropriate petition.
He has filed already.
He has filed appropriate petition. Appropriate petition is pending.
Now, what
Appropriate
made you
petition.
to
Why he
file
come
this,
for
file
this
this
civil division petition?
revision petition?
Where is the ground? No ground.
Where is
My lord, my learned friend submitted before your lordship. It is in his mind. It is in his mind that order will be passed and immediately his house will be broken down. Evicted, he will be evicted. That
which
is in his
order you
mind,
are impugning?
my lord.
You don't have a
Now,
case.
your lordship, another point I want to point out, in the review petition, in the present petition, my lord, civil revision petition, IO, that is not stated. Now he is orally submitting before your lordship, my house will be broken, that is why I have filed this civil revision petition. Is it a maintainable petition, my lord?
Saying in this case, it is
My
another
lord,
other case.
my humble submission before your lordship. Your lordship directed that you file appropriate petition. He filed appropriate petition. Without decision in the appropriate petition, my lord, he can file civil division petition here. It's completely misconception, my lord.
And the decree was obtained by law against that persons, that may can live order 22.
No, that you have taken plea in the review petition.
That is the political.
Since,
My
since I have understood,
Consider,
I have understood. Now let me dictate the,
suppose, so only my last submission is that if the review is dismissed, we have nothing to say. But we should be given adequate chance to
we
take.
don't know your review may be allowed. Why are you saying your review may be dismissed?
We allow, but it is the. talk of
You are
the-
so apprehensive that you know
No,
that
because
if-
it is the talk of their lawyers.
by the talk
in
of lawyers,
Kolkata. That's why my
Top
client
of
is.
the order,
since
find something is playing.
let this case be listed again on 14th of November. Since during submissions made by learned counsel for the both parties, it came out that a review application filed by the present applicant, which has been registered as miss case number 124/2025 is pending. And said review application was filed by the present petitioner in pursuant to the observation made by this court by order dated 28/5/2025, passed in IA within bracket civil 1686/2025. It appears that during the pendency of the aforesaid miss case, that is miss case number 124/2025, there is an unlikelihood of execution of the decree in title execution case number 45/2025. Therefore, the stay granted on the execution of title execution case number 45/2022 by order dated 19/8/2025 is hereby vacated. List accordingly. No stay,
Interim order. Vacated.
vacated.
Yes. That is the proper order.
Interim order is. And the other miss cases pending.
I have clarified why it is vacated. I have clarified in the order.
There is no merit, my lord. In the civil division.
Decree was obtained fortunately, that has not been.
You go through the order, it will be uploaded today itself.
Obliged.
May I please your lordship?
We fix 3 or 3:30? Okay. Epic phone call. Yes, what is your
Lordship.
case?
Lordship, already we have stated in our petition, Lordship, that there was a love affair between the victim girl and the present.
Since when you are behind the bars?
Lordship, today it's 202 days, Lordship, since 27/4/25, the 27th April, Lordship.
Charge sheet has been filed.
Lordship,
What is the status of the trial?
Lordship, the trial is going on, Lordship.
Victim has been examined.
Examine.
Victim has been examined.
Examine.
Victims. Let her be cross-examined.
Lordship, in the meantime, Lordship, the accused petitioner will cooperate, and he has been attending regularly, cooperating since 202 days, Lordship. It is his right, Lordship, to be protected.
What is the next date fix?
Lordship, no update, Lordship. No.
17th
7.
for cross-examination of the. Let the victim be cross-examined.
Lordship. If possible, Lordship, in the meantime, he may be released on any condition.
No,
Lordship,
no,
will
we are
follow.
reluctant to release. What is your submission?
So there are two material witnesses which I could gather again from page 37, your lordship, the charge sheet. So your lordship, let these two, if your lordship
thinks that it's fit that these two witnesses also may be.
In her examination in chief, victim has implicated.
Contents of the.
You have it.
Lordship, the fact of the case, Lordship, there was a relationship between the person's Lordship, but she came to know that she was pregnant. But already their relationship was,
Solved.
broke up. But after 6 months, she came to know that she is pregnant, hence she filed the affair, Lordship. When she came to know on February, in the month of February.
Okay, we'll take it up after 17th.
Lordship, after 17, any date may be fixed.
Heard Mr. S.K. Sarkar, learned counsel for the petitioner. Also heard Ms. M.K. Brown, learned amicus curiae for respondent number 2. Stop. Learned counsel for the petition. Learned amicus has submitted that the victim girl has the examination in chief of the victim girl has been completed and her cross-examination is fixed on the next date, that is on 17/10/2025. And therefore she submits that this matter may be taken up only after cross-examination of the victim girl. Stop. Though the learned counsel for the petitioner prayed for an interim bail during this period, however, this court is reluctant to do so at this stage. Let a report be called for from the trial court as to the proceedings of the court on 17/10/2025. The report should reach this court on 27/10/2025. Let this matter be listed again on 27/10/2025.
Earlier, Lordship.
You also take instructions
Lordship.
regarding cross-examination. Huh? Okay.
Earlier, Lordship.
May I please your lordship. Lordship, this is 482 bail application.
You are on interim.
Yes, I am on interim.
Heard Mr. What is your name?
Huda.
A.
Huda.
A. Huda, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, who submits that who prays for another date for producing the case diary. Stop. The prayer is allowed. Let this matter be listed on 27/10/2025. The interim bail granted to the petitioner on 8/9/2025 shall continue till the next date.
44.
May I please, your lordship, I am unable to contribute my senior counsel, your lordship, as he is on in medical emergency, your lordship.
Okay.
I leave it upon you, your lordship.
This is a condonation delay.
Condonation delay.
When he will be coming,
Tomorrow, he will come, your lordship.
we'll fix a short date. Heard Mr. S. Soikia, learned counsel for the applicants. Also heard Miss H.G. Daisy, learned counsel appearing for the respondent, who prays for an adjournment on the ground that her senior, who is conducting this case, is indisposed. Considering the submissions made by learned counsel for the respondent, the prayer for adjournment is allowed. Let this matter be listed again on 28th of October.
48. May I please, your lordship.
Yes,
Possibly the matter has become infructuous because the title execution case has already been disposed of.
disposed of.
Yes, ma'am. I have a copy of the final order as well as the Nazir report.
Yes, Mr. Sharma.
My lord,
It
there
has-
was, this is my proceeding, my lord. What happened? Earlier there was suit filed by them. And we are the defendants. But the total quantum of land, extent of land, was far below they have shown in the plan. Ultimately, in calculation, we found that it was 38 bigger and ours says 6 bigger. And in the midst of 6 bigger, their claim is 4 kata. And there is no boundary as such because huge plot, 6 bigger, and which portion of their land was, they have given some schedule that was not it. So ultimately, finding that, we filed a fresh suit telling the decree passed by trial court. That suit is pending. See, the suit is pending. We also filed an application under Order 21.
But here you are impugning the order of the executing court.
Hello?
In
Yes.
this case, what are you impugning?
Uh,
What are you challenging?
102, page number 102.
Page number 102. This is an order of the executing court.
Yes, on application under Order 21, Rule 29.
But if this title execution case number 7 has been disposed of,
Nothing remains, my lord.
yes,
So, my lord, this execution court passed the order that refused to.
no,
grant
no,
stay.
Mr. Sharma.
Yes.
The impugn order which was passed in title execution case number 7/2018.
Yes.
The case has already been disposed of. So what remains?
What you have decree was executed, but they couldn't take position yet. So because it's the midst of our land, so they are not in a position to, with the help of police, they came and.
No, we will not go into question of position.
Yeah.
In this revision petition, we are concerned with the impugn order only.
Yeah.
The order which has been impugned by you has become infructuous on disposal of the title execution case.
Yes, my lord. Even if it was disposed of, my lord, our claim under Order 21 to 29 remains. So, my lord, let the matter be admitted. It is already notice issued, they have appeared.
No, how the matter may be admitted in a case which has already been disposed
No,
of.
you will also be able to examine, since I am telling that, whether the impugn order passed here was legal or illegal.
No, that necessity does not arise now.
Because that was after this application filed, then only the decree was executed. It was pending before the court.
I'm not convinced.
So, my lord, before the execution of decree, this application was pending.
There was no stay, my lord.
If the stay had been granted, I would not come to court. I got. What Order 21 to 29 says, my lord?
Heard Mr. R.P. Sharma, learned senior counsel assisted by Mr. D. Dole. Also heard Mr.
D. Majumdar, lord.
D. Majumdar, learned counsel for the respondent.
Respondent.
This application under
227.
under Article 227 of the Constitution of India has been filed by the applicant / judgment debtor Hussain Ali alias Hassan, impugning the order dated 27/3/2025 passed by the executing court, that is the Court of Learned Civil Judge within bracket Junior Division Mangalde, in title execution case number 8/2018, whereby an application filed by the present petitioner under Order 21, Rule 29 of the Code of Civil Procedure was dismissed. Stop. Learned counsel for the respondent has submitted that this civil revision petition has become infructuous in as much as the execution case in which the impugned order has been passed has already been disposed of by the executing court by order dated 30/4/2025. (30/4/2025). On full satisfaction of the decree. Stop. In support of his submission, learned counsel for the respondent has produced a copy of the order dated 30/4/2025 passed by the learned Civil Judge Junior Division number 1, Mangalda, in title execution case number 7/2018. Let the said order be kept marked as X and kept in record as a part of record. Stop. Learned senior counsel for the petitioner has submitted that as the petitioner has raised a plea regarding illegal dismissal of his application under Order 21, Rule 29 of the CPC by the executing court in the execution case number 8/2018. The issue needs to be decided in this case.
Executing case is -7.
In,
7 or 2008.
oh sorry, in 7 of, you have mentioned wrongly in 7 of 2018 needs to be decided. So however, this court is not convinced with the submissions made by learned senior counsel for the petitioner, as the title execution case in which the impugned order has been passed has already been disposed of, and same is no longer pending. The instant revision petition, which has been preferred by the petitioner, has, in the considered opinion of this court, become infructuous. This civil revision petition is accordingly disposed of on becoming infructuous.
Well, only one observation will be required because fresh suit is pending, being titled suit number 43 of 2024. This order will not affect the merit of.
No, this will otherwise also not affect, because it is disposed of on the basis of this revision petition becoming infructuous.
Yes, ma'am.
You may pursue the title suit which is already pending. Observation is not required.
Much obliged. Much obliged.
I'm for the respondent and I want to file the objection. So some time may be given.
What for this IA is?
Condemnation of delay.
Condonation of delay. Heard Miss P. Bhagat, B. Agarwala, learned counsel for the applicant. Also heard Mr.
R.A. Majumdar,
R. A. Majumdar, learned counsel for sole respondent,
all respondent.
or learned counsel for all respondent, who prays for allowing the respondents some time to file written objection against the prayer for condoning the delay of 86 day made by the applicant. The prayer is allowed. The respondent may file the written objection before next date of listing. List this case accordingly after 2 weeks on a date to be fixed by registry.
Obliged.
Well, in this applicant is the wife and opposed party is the husband. Their marriage was solemnly on 12/5/2017. Thereafter, they living together a husband wife in the room of the backward of the main house of our matrimonial home. Thereafter, some dispute has been arised between them, and husband withdraw himself from the said room. Thereafter, husband filed a divorce petition.
You are husband or wife?
I am the applicant wife. I am the
Your wife.
Husband filed a divorce petition before Larned Family Court, seeking divorce on the grounds of cruelty and desertion. And during pendency, they regularly disrupted the electricity connection of the living room of the wife. My love. And wife is still living in the said room. My love. And thereafter, wife filed a petition before the Larned Family to install separate electricity separate submitter in the living room of the. And Honorable Larned Family Court has passed the order. Kindly see the order at page 20 and direction at page 23, my love. And direction page 23, my love. In the last part, I am reading, my love. After hearing both the parties, I deem fit to direct the petition to make arrangement for installation of separate electric submitter in the living room of the respondent. And the respondent is at liberty to install inverter in her living room by herself. Well, being agreed, they have preferred the instance CRP after 8 months of the passing order. And so I have filed same prayer, my lord. To comply with the instrument, this is the case, my lord. Simple, my lord. To install a separate electric submitter in the living room of the.
No, why this IA has been filed? For compliance of the order.
Yes, my lord.
But if the main CRP is dismissed, then they will automatically
My
comply.
lord, they have intentionally delayed the case, my lord. After passing of the 8 months, they have filed the CRP. Until that, they have complied.
Is there any stay in the?
No, my lord, there is no stay. Only notices was issued, my lord, in the cement CRP.
Then you go for execution.
My humble prayer is that the land where the present opposite party, husband and the petitioner is staying, is the land of the father. It is a government land, and his father has constructed some type house in the area, and the present opposite party husband has no right, title, and interest in that land. And there is no any jurisdiction of the honorable principals of family court to pass this order, because I have the concerning party, the husband, has no any right of that property. The father is the occupier or the possessor of that land, and he has constructed the house, and one person of that house, the wife is staying, and there is no, they have firstly stated that we have disrupted the electricity connection, and it is as per the APDSL norm, the regularly electricity connection is provided to that room along with the other house of the
Opposite party.
No, CRP sir. Main CRP. Instead of taking up IA, we can dispose of the main CRP. Same issues are involved in both the cases. Are you ready to argue the CRP? Main case today.
Because, we have to mention, submit some document along with our additional affidavit, maybe we're going to file.
Well, they have that, date may be fixed if they, honorable could ask, on 26/5, they have.
Today is the,
Well, kindly page the order.
we'll give a fixed date.
Yes, my lord.
Common order लिखिए. Common order, IAN. Heard Mr.
Clearly.
A. Ali.
Clearly.
T.
Yes, my lord.
Heard Mr. T. Ali, learned counsel for the petitioner. Also heard Mr.
DK Bordole.
D.K. Bordole. No, heard Mr. D.K. Bordole, learned counsel for the petitioner. Also heard Mr. T. Ali, learned counsel for the respondent. Though the respondent has filed an interlocutory application which has been registered as IA 1431/2025. However, as the relief prayed for in the said interlocutory application may ultimately be granted or rejected subject to the outcome of the instant civil revision petition, this court is inclined to expedite the hearing of the instant civil revision petition instead of considering the interlocutory application at this stage. Stop. Learned counsel for the petitioner has submitted that petitioner needs some time to file an additional affidavit and bring on record some documents relevant to this case. The prayer is allowed. Let this case, when will you file? 24 next week.
Yes,
The prayer is allowed. Let this case be listed again on 24th of October.
41. My lord, the respondent number 2 died during the pendency of this case. And while filing an application by the legal heirs of this respondent number 2 before the learned trial court, thereafter we came to know. And so there are 3 now. One is for condoning the delay, and another one is for setting aside the abatement. And the third one is for substitution of the legal representative. I understand is preparing for the.
Delay condonation.
Yes, my lord.
You are opposing or conceding.
As your lordship, please.
Your smile indicate that you are conceding. Mr. B. Bora, learned counsel for the petitioner. This application under Section 5 of the Limitation Act 1963 has been filed by the petitioner for condoning the delay of 97 days in filing the application for setting aside of abatement, as well as filing petition for substitution of the legal representative of legal heirs of deceased respondent number 6. Stop. Where,
No,
where,
my lord, two.
this is respondent number
Two.
2,
Subodhuti Gautam.
namely Dhrubajyoti Gautam. Learned counsel for the petitioners has submitted that where have you stated the reasons? Reasons for delay.
Para 9. Para 9. Page 5.
That though the respondent number 2 died on 13/11/2024, however, the petitioners came to know about the said fact only on 21/1/2025. So, the learned counsel for the petitioner has submitted that the petitioner has explained the grounds for delay in approaching this court for filing setting aside of abatement and substitution petition beyond the prescribed period of limitation in paragraph 9, 10, 11, and 12 of the 9, 10, 11 of the condonation of delay application. Learned counsel for the respondents, considering the grounds you are conceding.
My lord, cost may be awarded because after the abatement, I got a finality
You got a,
finality of the abatement. That
you're ready to pay costs. How much?
yes,
As a lordship.
Token costs.
Token.
No costs. Stop. Learned counsel for respondent has submitted that since after abatement of the suit against respondent number 2, the suit against respondent number 2 got finality, and therefore, if the delay is condoned at this stage, some cost may be awarded. Stop. I have considered the submissions made by learned counsel for both sides. Considering the submissions made by learned counsel for the petitioner, as well as grounds stated in paragraph number 9 to 11 of the application for condoning delay, this court is of considered opinion that the applicant has been able to show sufficient cause which prevented him from approaching this court for setting aside abatement and substitution of the legal heirs of respondent number 2 within the prescribed period of limitation. Stop. For the aforesaid reasons, this court is inclined to allow this application and condone the delay of 96 days, 97 days, 97 or 96? 97 days, upar sub 97, 97 days in filing the application for setting aside of abatement and substitution of the legal heirs of respondent number 2. Where is the setting aside of
My
Hmm.
lord, that is 1756.
1756 abatement? Not Mr. S. Jain, sorry, S.
B. Bora.
B. Bora, learned counsel for the petitioner. Also Mr. R. K. Jain, learned counsel for the respondent. This application under Order 22, Rule 9 of the Code of Civil Procedure 1908 has been filed by the applicant for setting aside of the abatement on abatement of this case on death of respondent number 2. Stop. I have heard submissions made by learned counsel for both sides. The reasons shown by the applicant in the application under Order 22, Rule 9 of the Code of Civil Procedure appears to be just reasons. Justifying a favorable order to the petitioners in this case. Hence, considering the reasons shown in the instant application, the abatement of suit on the death of abatement of the case on the death of respondent number 2 is hereby set aside. And this interlocutory application is allowed. Substitution. এটুই হাতে রাখি বন্ধ করে রাখি। Lord Mr. B. Borala, same council on name ke likhibo. This application under Order 22, Rule 4 of the Code of Civil Procedure 1908 has been filed by the legal heirs of
For substitution.
by the petitioner for
Substitution of the legal.
for substitution of the legal heirs of deceased respondent number 2 in the connected civil revision petition within bracket IO number 437/2024. It is submitted by learned counsel for the petitioner that though the instant case got abated on the death of respondent number 2, however, the said abatement has been set aside by this court by order dated 15/10/2025 in IA number 1756/2025. He further submits that who are the legal heirs?
Para 5, my lord.
He further
Lord,
submits
page
that
number 5.
names of the legal heirs of respondent number 2
One correction maybe is the C, it should be Master Ranbir Gautam instead of Miss
has been
Ranbir Gautam,
stated
because he is
in
the son.
paragraph number 5 of the substitution application. So considering the grounds mentioned in the said petition, this court is inclined to allow the substitution petition. Accordingly, the registry is direct. You will file a amended cause title. Amen. Accordingly, the names of legal heirs of respondent number 2, namely Shri Miss Kaustavi D. Sharma, Mrs. Kaustavi D. Sharma. MS we can use for both married and unmarried. When I'm saying Miss, it is not MISS, it is MS. Miss Kaustavi D. Sharma, wife of the deceased respondent number 2, Ms. Jaishnavi Gautam, daughter of the deceased respondent number 2, and Ms. Master Ranveer Gautam, son of the deceased respondent number 2, may be substituted as respondent number 2 within bracket A, 2B, 2C, respectively, in the connected civil revision petition within bracket IO 437/2024. The petitioner is directed to submit an amended cause title incorporating the name of the substituted respondents in the said amended cause title. Let the
This may be issued to them.
after
Yes.
let the connected CRP number 437/2024 be listed again after filing of the amended cause title.
Okay.
This interlocutory application is accordingly disposed.
Okay, that's fine.
My lord, in this case, I have filed a petition, Miss IA civil number 1851/2025. My lord, here respondent, pro forma respondent number 1 died. And the only one legal heirs who is already there in the pro forma defendant number 2, my lord. He is already in the record. So, my lord, I have filed this petition that legal heirs of deceased pro forma defendant number 1 is already in the record. Case may proceed, my lord, against him.
What is order 22 rule 2?
But this is order 22 rule 2, my lord. Procedure where one of the several plaintiffs or defendants dies and the right to sue survives. Where there are more plaintiffs or defendants than one, and any of them dies, and where the right to sue survives of the surviving plaintiff or plaintiffs alone, or against the surviving defendant or defendants alone, the court shall cause an entry to that effect to be made on the record, and the suit shall proceed at the instance of the surviving plaintiffs or plaintiffs, or against the surviving defendant or defendants.
Okay. You don't have any objection. Heard, Mr. PC Day, learned counsel for the applicant. Also heard Mr.
I'm appearing on behalf of Mr. N. Bharani.
A. Bhuya appearing on behalf of Mr. N. Bharali. This interlocutory application under Order 22, Rule 2 of the Code of Civil Procedure 1908 has been filed by the petitioner Arun Gogoi within bracket. Petitioner number 2. Petitioner number 2. Who died?
My lord, pro forma defendant number 1. Pro forma defendant number 1, Lavanya Das.
Lavanya Das was the petitioner in this case.
No, my lord, the pro forma defendant number 2 in the review petition.
In the review. And in this CRP?
CRP Arun Gogoi is the review, is the petitioner, my lord.
I'm for the opposite party number 1.
CRP to Dioksu. Who were the petitioners
Petitioner is Arun Gogoi, my lord.
in CRP?
Yes.
And,
As well as the miss case also.
and who died?
My lord, the pro forma defendant number 2, Lavanya Das, Srimati Lavanya Das.
Lavanya Das.
Lavanya.
And who is the legal heir of Lavanya
My
Das?
lord, that is Sudarshan Krishna Das, number 3.
Okay. क्या लिखा? Has been filed by the petitioner Arun Gogoi for allowing the present CRP number 18, allowing the connected CRP number 18/2021 to proceed against the respondents who are on record, including the respondent number 3, Sudarshan Krishna Das, on death of Srimati Lavanya Das, who was earlier arraigned as pro forma defendant number 2 in the said CRP. Learned counsel for the petitioner has submitted that Srimati Lavanya Das had expired on
My lord. My lord, it was actually date, my lord, it is not known, but in the. before the
had
honor-
expired, leaving behind the respondent number 3
3.
as her sole legal heir. And therefore, there is no necessity of substituting the legal heirs of respondent number 2, as Shri Sudarshan Krishna Das is already on record as respondent number 3. He therefore submits that as the right to sue survives against the surviving defendant, that is respondent number 1 as well as respondent number 2, the present civil division petition may be allowed to proceed against the surviving defendants alone. Stop. In terms of the provisions of Order 22, Rule 2 of the CPC. I stop. Learned counsel for the respondent does not opposes the prayer. Stop. Considering the submissions made by learned counsel for the petitioner as well as concession made by learned counsel for the respondent, this application under Order 22, Rule 2 of the Code of Civil Procedure is hereby allowed. The connected civil division petition number 18/2021 shall accordingly proceed only against respondent number 1 and respondent number 3. The registry is directed to strike out the name of respondent number 2 from the cause title of the civil division petition. List the connected civil division petition after that on a date to be fixed by registry.
My lord, here, earlier notice was issued, but it is not duly served. My lord, I may be allowed to take fresh step against this respondent, my lord.
In main case, heard so and so, in pursuant to the orders passed in IA number 1851/2025 under Order 22, Rule 2 of the CPC, the registry shall make necessary corrections in the cause title as directed by this court in the aforesaid order. Stop. Learned counsel for the petitioner has submitted that the petitioner may be allowed to take fresh steps for issuance of notice on both the respondent.
No, my lord, one appeared.
Oh, yes, issuance of notice on respondent number 3.
Now it will, one,
Three.
2 is struck.
No, it will remain as 3.
Yes,
Respondent number 3,
Sudarshan Krishnadas.
Shri Sudarshan Krishna Das. The prayer is allowed. The petitioner shall take steps by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks, list accordingly.
Yeah, please, Your Lordship. My lord, I am appearing on behalf of the respondent number 1, 5, and 7.
No, before you proceed, I am reluctant to take up this matter. It may not be proper. Heard Mr. R.C. Sancheti, learned counsel for the complainant, learned counsel for the petitioner. Also heard Mr. R.K. Sharma, learned counsel appearing for respondent. This court is reluctant to take up this matter for obvious reasons. Place this matter before any other bench without me.
One minute, Lordship, interim to continued.
Your Lordship, in the main petition, we are for the petitioner. Yes. And I break file for stay equity. So in that we are responding.
We'll direct registry to list it.
But I filed the application for vacating the stay order. Since this honorable court has directed to list the matter before any other branch, automatic that will continue. That is till the returnable date.
Yes. Still we let us pass an order. In main case also, same order. The interim order shall continue till next date.
In the main case, service remain incomplete in respect of respondent number 3, 8, 9, 10, 11, 4, 6.
No, that will be passed by the next court.
It is a confirmation of delay application. Lordship has to issue notice has not yet been issued. For 86 days.
Notice will go. Heard Mr. B.P. Bora, learned counsel for the petitioner. Also heard, no, this application under Section 5 of the Limitation Act 1963 has been filed for condoning the delay of 86 days in filing the connected review application. Let the notices be issued to the respondents. The petitioner shall take steps for issuance of notice upon the respondents by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks, list accordingly.
45.
May I please? May I please? Your Lordship?
Yes.
Lordship, this interlocutory application has been filed for releasing the 50% deposited amount, which has been already deposited before the registry.
You have any objection?
Yes, Lordship. Because Lordship, this is, our appeal is based on the.
Then
fact
file objection. You will be filing written objection
and
on
our
all mode.
Lordship, it can be heard. Finally, the LCR has also come, Lordship. Any day, next week also I'm ready, because we are saying that false claim has been made.
Case
FIR is filed after 6 months, 3 months.
But in the Lanet code below, they are not reduced any evidence.
No, it is on your document itself, cross-examination of it.
Whether service has been complete.
Lordship,
No,
in fact, this is, the service can be still served because it was served in July itself. And moreover, Lordship, in this case, we are not saying the policy was not there. There is no, we are on the accident itself, which is related to the claimant only, not related to the owner and driver. That we are not challenging the policy here. So their notice was sent on 21/7/2025, both ways of office notice, their Lordship.
21/7.
Yes, Lordship, this year itself.
Then
So it can be
we-
deemed served,
no,
Lordship.
Let us try for an track consignment report.
Yes, that will be. But they are basically for hearing, they are not necessary. For hearing, only both of us are necessary.
Still one chance.
Yes.
In main case लिखिबो.
Lordship, this matter pending in the year of, since 2020, your Lordship. And petitioner claimant is the SS final year student. And the amount is not big amount, your Lordship, only 2 lakh.
Question is not a big or law.
No, we'll finally dispose of the case.
That is the.
We'll decide your case,
Lordship.
finally decide. Heard Ms. R.D. Majumdar, Learned Counsel for the appellant. Also heard Mr.
Yes,
S.I. Ahmed,
Akand.
S.I. Akand, Learned Counsel appearing for respondent number 2.
One.
Respondent number 1. It appears that notice issued to respondent number 3 and 4,
2 and 3.
2 and 3 has not yet been returned back. The registry is directed to submit the track consignment report of the notice issued to respondent number 2 and 3 by
And also the chip, the usual process was also taken. They had said.
by registered post with AD as well as by registered post with AD on the next date fixed. That is on when?
Any date, Lordship, I do not have any objection. Go on, Nitya Nagar.
28 October. 28 October 2020. Since due to objection raised by the Learned Counsel for the appellant in the connected interlocutory application for releasing the 50% of the money which has been deposited by the appellant before the registry, this appeal is required to be decided expeditiously. Accordingly, registry is directed to place the track consignment report as directed without fail on the next date fixed. Place this matter on 28/10/2023.
Highly object,
So-
Lordship.
May please the Lord. In this matter, we had taken steps upon respondent number 2 and 3, but as per office note, there are 2 contradictory statements, Your Lord. 2 contradictory notes.
What are the contradictory notes?
4/9/2022, it states that we have taken steps, and on 8/10/2025, it states that we had not taken steps. The steps have not been received by the registry.
Now, whether you have taken steps
Yes,
or
Your
not,
Lordship.
yeah,
On the very last, your lordship may find the notices.
No, because you were directed to take fresh steps.
On 1/9/2025.
Okay. What is to be done?
Basically, may submit a report in this regard if it has been served or not, because proper report has to come. Because notices are there in the
Heard Mr. S. What is your name?
J Das.
J. Das Leonard, counsel for the appellant. Also heard. What for the interlocutory application?
It is for injunction. Injunction, your lordship.
Learned counsel for the appellant / applicant. Also heard Mr. A.K. Gupta, learned counsel for respondent number 1 / opposite party. Number 1. On perusal of the office note, it appears that there are 2 contradictory office notes as regards to taking of steps by the petitioner for issuance of notice on respondent number 2 and 3. Stuff. Though by office note dated 4/9/2025, it appears that the petitioner, that the appellant has taken steps for issuance of notice on respondent number 2 and 3 by registered post with AD. However, a contradictory note has been put up on 8/10/2025, indicating that no steps have been received. Stop. Since the office note dated 8/10/2025 appears to be contradictory, same is ignored. The registry is requested to be alert in preparing office note, which are intended for the courts. Stop. The registry is further directed to verify and place the track consignment report of the notices issued through registered post with AD to respondent number 2 and 3 in pursuant to the office note dated 4/9/2025, before this court on the next date fixed. Let this case be listed on
17th of November.
17th of? 17th of November.
Declare.
May I please your lordship? This interlocutory application was filed for a combination of delay, but there's a slight difference in this.
For what purpose?
For combination of delay,
Heard, Mr. What is your name?
Y.N. Mahanta.
Y.N.
Y.N.
Mahanta, learned counsel for the applicant. This application under Section 5 of the Limitation Act 1963 has been filed for condoning 700 days of delay in preferring the connected MSc appeal, intended to be wherein the judgment and award dated 2/2/2021 passed by the Motor Accident Claims Tribunal Kachar in MSc case number 701/2017 has been impugned. Issue notice to the respondents. The applicant shall take steps for issuance of notice to the respondent by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. Who is for the other side? Yes, we have 26 minutes left.
Yes.
Is it enough?
To conclude,
Yes, no.
Oh.
If we start, it will become part hard.
yes.
That we can do. Or you can choose to, because experience with part hard is not
can
very
understand.
good.
Or else we can finish off with.
Though you
finish it off
have
with one go.
come from Calcutta.
It's as much as possible. But because your lordship is going to hear this for the first time, so your lordship may be having certain queries because it is essentially under section 430 of the Companies Act.
Then I'll be having lot of queries.
Yes, my lord. So whether lower court can decide that suit when NCLT is already in session of all the three companies. They have claimed the properties of the companies as the undivided family properties. That is the main issue. Now, because that is a legal entity, companies are legal entities. Companies' properties have been impugned as undivided properties of a Muslim family.
Okay.
So that is completely against the legal entity concept. Because in order to divide the properties of the companies, my lord, liquidation is required first, because companies are required to be liquidated. If at all it is taken as undivided properties, first liquidate the company. For liquidation, my lord, the jurisdiction is vested with the NCLT under section 5, under NCLT under section IBC of.
How much time will you take?
I will, in fact, my lord, I would have suggested, my lord, even if my friend begins, I will do my part on a different day. I have a toothache.
Yes, today it is not.
No,
So,
then-
or else we can start and finish it off in one go.
Yes,
Perhaps that.
let us adjourn it. You can choose a date,
30th.
30, on a hearing day.
29.
30 hearing day, I say. 30. Yes, Mr. Dekha.
No, 30, I have a few matters.
You choose a date with
29.
mutual con.
There is, but I'll seek an adjournment at NCLT time.
29.
29. 29, same thing will happen. It is not a hearing day.
Then maybe 4th of November.
Fix.
Give me an item number.
Sixth.
6th, we have few matters fixed.
First, the 6th I'm coming. You were there in that? No, you were not there.
No, they,
Interesting.
okay, exactly.
Interesting.
6 is okay.
6 is already met. If there is one
There are
matter,
other
there is
matters.
no
No,
witness.
I don't have any objection.
Well,
Because
we'll,
both
I will not detain your lordship. We'll coordinate and tell the court.
Okay. Heard, Mr. What is your name?
Akhilesh.
Akhil. A.K. Shrivastava, learned counsel for the petitioner. Also heard Mr. B.D. Dekha, learned counsel for the respondent. This matter could not be taken up for hearing due to paucity of time. Hence, let this matter be fixed on dash blank for hearing as a fixed item.
My name may be reflected.
The name of Mr. B.D. Dekha may be reflected in the cause list as engaged counsel for respondent henceforth.
Deeply applied.